else I may be allowed to make a criminal petition tomorrow.
Day after, not tomorrow.
Wednesday? Public.
Did you file?
We have filed filing number.
May I please, my lord, I recommend for listing a criminal revision petition, my lord, which was, my lord, earlier listed on 27th March 2024, my lord. There was a direction list after 3x, my lord, but still that not listed there.
Friday.
Obviously.
May it please, your lordship. Lordship, I beg to mention item number 15, lordship. Can it be taken up at 2, lordship, or second half, lordship?
Hello.
Right, please, your lordship. Prayer for listed one criminal petition 495/24, lordship.
When did you file? When it was last listed?
Last listing, that is 29/4/24, lordship, in the month of April.
16.
16.
Yes.
Please, your lordship. I beg to mention an item for listing an IA in criminal revision petition. It was filed on the 1st of August. It has not been listed yet, lordship.
Friday.
May I please, my lord. Okay, I beg to mention item number 32, my lord.
Item number?
32, my lord.
Huh.
Lordship may take up at 2, my lord.
Okay.
Obviously.
May I please, lordship, prayer for listing a criminal petition, lordship. Last occasion, lordship, it is 23/4/24, lordship. Can it be come up next week, lord?
Monday.
May it please your lordship. My lord, I beg to mention item number 19. My lord, the petitioner has filed a second additional affidavit today, which may be called for.
Have you served copy on the counsel for the
Your
petition?
lordship, may I please, your lordship, our consent was not taken, so my senior said that she will do the case today because the matter relates to execution petition, so it's very urgent, so.
You have received copy?
Your lordship,
You have received copy?
We are not taking time. We are following the original affidavit.
okay, okay.
Have you received the copy of the additional affidavit?
We have filed it.
Okay.
Filed it, ma'am.
Okay, you bring it.
Yes, sir.
But without serving her a copy.
We'll
you
start,
don't-
my lord.
My lord, I will make item number 39, my lord. May I pray for taking up the matter at 2 o'clock, my lord?
Okay.
39.
May I please, your lordship? Lordship, I beg to mention item number 13, 1-3. Due to some personal difficulties, the engaged counsel of the petitioner could not be present today. So I pray that the item be adjourned for today.
And the
and be
counsel
listed.
for- Okay.
Thank you.
Yes.
Hello. I beg to mention in item number supplementary, item number 53. This is a fresh appeal which has come up today for the first time. My lord, along with this appeal, we also filed an IA for suspension of the sentence in view of the fact that the total sentence awarded is 3 years, 6 months, and he has already been in custody for 1 year, 10 months. So, my lord, somehow the IA has not been listed today. So, my lord, I'll give a requisition, my lord, that IA may kindly be called for, my lord, because we filed it on the same day.
We can call it for, but first to verify whether any defects or not, then only we can pass it.
My lord, to whatever little I have instruction, my lord,
You
to my-
verify and make a mention, otherwise it will come tomorrow or day after.
tomorrow or day after, my lord.
You verify first,
I'll verify.
then only you make a mention. Okay?
May I believe that? So with concern of the other side, I beg to mention item number 10, lordship. My senior is operation lordship, Saturday. Lordship, kindly pass over the day and thereafter 3 weeks left. 10.
For a week. Okay.
Obliged.
We have counsel for the parties.
May it please your lordship. Otherwise, this is a criminal revision against the judgment of the District Session Judge Pakumpare UPR. My submission would be this matter was filed at that point of time because of the COVID situation. And this matter can be transferred to the original
Because it jurisdiction lies at the state of Arunachal Pradesh, right?
and both the parties are from Arunachal itself. Your lord.
My lord, there is only one, my lord, there is only one aspect of the matter, my lord. When this matter was initially moved, my lord, in the year
There was an interim order.
2020, my lord, there was an interim order subject to the condition that they are required to pay 8 lakh rupees, my lord, in terms of section 148 of the Negotiable Instrument Act. Now, my lord, after
That prayer you will make before the.
no, my lord, this, my lord, after a
That
lapse of
interim
4
order has
years,
also
after a lapse of 4 years, my lord, only 5 lakh rupees is paid, that too on the last occasion, and that money is pending before the registry of this court, my lord. And my lord, my client is out of station. He will be coming on 16th of August, and then only he can collect that check, my lord.
That can be done, we can allow.
There's already a judicial order to that effect. And the sentence, the suspension, that has also been vacated, lordship.
Cancelled.
Cancel, my lord, because
Yes.
they have failed to
So
comply with the
therefore,
order.
so what is
There is
there?
nothing.
So therefore, I request lordship to send the matter back to the original bench.
Okay, as Mr. Biswas is making, we'll have it on Monday next,
Monday next.
on repair of council for the parties published on.
Monday, my lord, any day barring Monday, Tuesday, I'll not be there, my lord. Date, what is the date? Date, Monday. Huh?
21st.
21st, I'm obliged.
21st.
Yes,
Obliged.
Mr. Sharma?
Yes, your lordship.
May it please the lordship. Lordship, this criminal petition, lordship, regarding we have purchased one vehicle, lordship, and at the time of purchase, where during finance, lordship, we have deposited some post-dated check, lordship. On the basis, as there was some due, lordship, 65,000, they have utilized that check, and thereafter NI Act case was initiated. That I have challenged by this criminal petition, lordship, for quashing. Lordship will find annexure 1, page 15, lordship. Name of the customer, lordship, there is a name of the petitioner, lordship. And finance company, that's a respondent number 2, lordship. Certified that traveler TD2BS so and so, lordship. With engine number and all this. Then, lordship, that annexure 2 is lordship Cholamandalam's letter. That with reference to my traveler, that through that letter, I have surrendered the vehicle, as after some days I could not ply the vehicle, lordship. There is some lordship disturbance in the utilizing the vehicle. So I have accordingly surrendered the vehicle. This is the surrender letter, lordship. Annexure 2, page 16. Your lordship will find there is an acknowledgement by the respondent number 2, lordship. With reference to my traveler vehicle loan taken from your company against the above loan agreement number, I would like to inform you that I am unable to pay my monthly installments, and hence I am voluntarily surrendering the vehicle bearing registration number so and so to your branch office. You are empowered to sell the vehicle and adjust the sale proceeds against my dues. That surrender letter is dated 25/10/2018. So in the years 2016, I have purchased, and 2018, I have already surrendered. Thereafter, lordship, they issued a letter to me, that is annexure 3, page 17, lordship. Kindly refer to our various communication to you with regard to the aforementioned loan agreement you have entered with us for the purchase refinance of the vehicle Traveler 26 so and so. Despite several opportunities to you, we find from our records that your account is still in arrears, wherein you have not taken any effort to repay the outstanding till date. We give below the amount due from as on 12/5/2019. Total amount payable 96,566, lordship. Then, lordship, they have issued a notice to me, that is annexure 4, page 18. by an advocate, lordship. There also it mentioned that subject your lordship will find payment of outstanding amount of rupees 96,566. That is dated 13/5/2019, lordship. In response to that notice, lordship, I have given my reply, that is annexure 5, page 19, lordship. In the reply, lordship, I have stated that in para 2 that my client availed a vehicle finance loan from you wide loan number so and so for the purpose of purchasing a traveler vehicle from the dealership of Force Dibrugarh. After due verification, your authority have sanctioned the loan for the purpose of purchasing the aforesaid vehicle, and the vehicle was registered at Tinsukia bearing registration number so and so. That due to my client's some personal difficulties, he was unable to ply the said vehicle, and on 25/10/2018, my client intimated the matter to Ankur Chakraborty, manager Cholamandalam Investment and Finance Company Limited, Dibrugarh branch, and he suggested my client to surrender the aforesaid vehicle at your office at Sibsagar branch. And as per his suggestions, my client have surrendered the aforesaid vehicle along with relevant documents at your office at Sibsagar. The aforesaid vehicle along with documents have been received and acknowledged by Sri Anuj Kumar Gogoi of Cholamandalam Investment and Finance Company Limited, Sibsagar. That my client, being a reputed person, cleared all his dues till the date of delivery of the aforesaid vehicle to your authority, so that the question of defaulter does not arise at all. Moreover, you have no right to classify the aforesaid loan as non-performing asset. That my client cleared all his dues, so he is not at all liable to pay any amount to you. That you and your office staffs are trying to cheat my client and harassing him only to grab money from him. That at the time of availing the aforesaid loan facility, my client delivered you few checks as per your request, which is not yet used by your authority, which is required by my client, as there is no any need of the checks by you. That my client have come to know that after the surrender and delivery of possession of the aforesaid vehicle to you, your authority have delivered the said vehicle to third person without the knowledge of my client, and receiving the EMIs from him, third person of the said
Yes, Mr.
vehicle.
Day.
Lordship.
Mr. Day.
My lord.
Initially, it appears from the legal notice issued to the petitioner, that only 95,000 and odd amount, 607.55. Where from this 6 lakh popped up?
I'll just stick to that. Lordship will kindly come to page 17.
Lordship, that suddenly become, lordship, some lakhs amount.
Yes, 17.
My lord, this is a case, my lord, where it should be dismissed with exemplary cost, my lord. While I'll submit, my lord, Lordship will kindly come to page 17. I'll just clarify that point first. Is the, my lord, initial notice? Now, Lordship will come to despite the second paragraph, despite several opportunities to you, you find more from our records that your account is still in areas where you have not taken any effort to repay the outstanding. We give below the amount as on 25/12/2019. That was the outstanding installments due. Now, my lord, the check amount is the entire loan amount, my lord. Both are different, my lord. Now, what has happened in this case, my lord? Complete suppression of facts, my lord. Here, what has happened, my lord? The petitioners, my lord, during the substances of the agreement, he sold off the vehicle to a third party. Now, what had happened, my lord? Thereafter, that third party sold it to some other party, my lord. Lastly, my lord, there was an agreement executed. I'll just place that document, my lord. It is already on record in a different criminal proceeding. He sold the vehicle to one Kiran Gogoi, my lord. Lordship will kindly go through the agreement. So all disputed facts, my lord. Lordship will see it is executed, my lord, second page, my lord, with one Kiran Gogoi. Now, Lordship will kindly come to the next page, internal page 3. Whereas the first party on 27/10/2007, that is their document, my lord. That is 27/10/2017, entered into a deed of sale in respect of the aforesaid vehicle at a consideration of 2,60,000 with one Noyanmoni Aradhana.
Next paragraph, whereas the convenience of the said agreement, Sri Narayana Modi Aradhan undertakes the liability of the remaining installments of rupees so and so. Now, Lordship will see the next paragraph again. Whereas the said Narayana Modi Aradhana, without the consent and knowledge of and without obtaining any written permission of the first party on 3/3/2018, entered into a deed of sale in respect of the aforesaid with the second party. Now, second party is Kiran Gogoi, my lord. Now, what had happened, my lord? Kiran Gogoi refused to pay the installments. He sold off the vehicle, my lord. The loan was already subsisting, my lord. Thereafter, the petitioner approached us. And in fact, my lord, he approached us and this with a request to issue a solution, to give him a solution. So we, after discussion, we issued a surrender letter. Without delivery of the vehicle, my lord, there was a symbolic surrender. Now, what had happened, my lord? Thereafter, on the basis of the surrender order, he lodged an FIR against us. And in fact, my lord, there is a, my lord, criminal petition pending. I'll just, my lord, I'll place that order also, my lord.
Lordship, these are different aspects,
No,
Lordship.
but
Those
all interconnected. I'll just.
Lordship, those documents are not brought before your Lordship by way of affidavit in opposition, Lordship.
No, Lordship,
No affidavit in opposition filed till date, Lordship. He entered his appearance much more earlier than this date, Lordship.
I'll rely on decisions of the apex court, my lord. Where disputed facts are there, my lord, Lordship will not enter into it.
Lordship, surely, Lordship.
But
that
in fact, if
for
Lordship, this is
disputed
the
facts, Lordship, civil proceeding has to be filed, Lordship.
well, Lordship.
How this NI Act proceeding is maintainable, Lordship?
The Lordship will see this is against the FIR, my lord. In this, even otherwise, if your Lordship tags the matter with criminal petition 1345, everything will be, my lord, clear. My lord, he approaches the court misleading facts. In the other criminal petition, my lord, we have annexed documents to show that the Kiran Gogoi approached us to transfer the vehicle in his name. Those documents are already on record, my lord. And even otherwise, my lord, they make a statement that the arbitration proceedings were initiated, they participated. No, my lord. It was decided ex parte. Whether it is legally enforceable debt or not, my lord, these are matters of evidence, my lord.
Why you have placed this judgment?
Lordship, this my lord, on the basis of the surrender letter, my lord, they lodge an FIR. They say, my lord, that we have surrendered the vehicle, but they have been issuing notices to me. And the FIR was registered, my lord, it was charge sheeted. Against that, my lord, I have come under my lord, 482. Bringing on all the records, my lord. And the Honorable Court was pleased to, my lord, after going through records, they were pleased to stay the proceeding of the case, my lord.
Lordship, that is a different aspect. Lordship, I filed an FIR against that surrender letter, Lordship. They have prayed for quashing of that my FIR, Lordship. That is different. Here, law point is, Lordship, whether post-record check given by the petitioner while purchasing the vehicle can be utilized for 138 proceeding, Lordship. I have citations, Lordship, in this aspect that different high courts and Supreme Court said post-dated checks is not involved in a Lordship 138 proceeding. And moreover, Lordship, on May 2019.
Counsel appearing for the petitioner, NMS, and Mr. RD, that counsel appearing for the respondent number 2 complainant. Also heard MS as Rahul and December the prosecutor appearing for the state respondent number for proper adjudication of this criminal petition. The records of criminal petition number 1345/2023 in bracket Anush Kumar Gogoi and another versus State of Assam and another. Is necessary. Access. Release this matter on Friday, Bitu Bharari, 16. Along with the records of release this matter on Iman, along with the records of criminal petition number 1345203.
I have interim, Lordship.
On Friday,
Lordship, interim to be continued.
on the next date of this, the interim order passed earlier on 29/04/2022 shall remain in force.
Sorry, my lord. I have mentioned item number 3, Lordship. In this case, my lord, item 3, 10, Lordship.
Yes.
There is a interim, Lordship. Interim may be continued, Lordship.
Okay, we'll verify. Yes, Mr. Halu.
Yes, Lordship. Lordship, this is a criminal petition challenging the order of learned session judge, wherein Lordship, the petition filed by CBI for setting aside an order of Juvenile Justice Board has been rejected, Lordship. Lordship, the impugned order is at page 20, Lordship. What happened in this case, Lordship? In the year 2012, Lordship, there was certain dispute which has been taken place, some incident, Lordship, for some ethnic group, ethnic violence in the district of Chirang, Lordship. That case has been registered by Assam Police. Subsequently, it has been given to CBI for investigation. And CBI, after conducting investigation, Lordship, they submitted charge against 3 accused persons. 2 of them are juvenile, and therefore they were sent for trial before the Juvenile Justice Board. And Lordship, during trial, Lordship, witnesses were examined. However, Lordship, the special PP has been appointed by CBI. His tenure was fallen due, Lordship, and the process has been initiated to give appointment, Lordship. In the meantime, Lordship, on 16, Lordship, the case was fixed for evidence. However, as nobody has turned up, the case was closed. Prosecution witness was closed, Lordship. That order has been challenged before the session judge, and the session judge upheld the order with Juvenile Justice Court. That is the case, Lordship, not still, Lordship. In view of section 14 of the Juvenile Justice Act, Lordship, that was prosecution witnesses were closed, Lordship. In spite of the fact that there are some important witnesses which are yet to be examined, Lordship.
Yes, Mr. Roy, please come to page number 25. Read from para 10.
Para 25, Lordship.
Page number 25, para 10.
Para 10, a bare provision section 14 of the Juvenile Justice Act, Lordship, that is there, Lordship.
Kindly read.
Yes. A bare reading of provision 14 of the Juvenile Justice Act reveals that the inquiry has to be completed within a period of 4 months from the date of first production of the child before the board, unless the period is extended for the maximum period of 2 more months by the board, having regard to the circumstances of the case, and after recording the reasons in writing for extension. Further, for serious and heinous offences, in case the board requests further extension of time for completion of inquiry, the same shall be granted by the chief judicial magistrate, or as the case may be, the chief metropolitan for reasons to be recorded in writing. So if provision is there for
Then
further,
please come to page 26.
yes. In the instant case, the case was at the evidence stage for more than 8 years. Now the prosecution has failed to produce witnesses in spite of giving sufficient time. It is seen from the record that the evidence of the prosecution has been started since 2013, and as many as 89 dates were fixed for prosecution witness. It also appears from the record that the statement of defense of the accused persons were dispensed with due to incriminating material, and the case was fixed for argument and judgment. It is further seen from the record that the learned court below fixed on 23rd 12/2022 at the last chance for prosecution, but the petitioner failed to examine the witness. Accordingly, it is observed that the learned court below has rightly rejected the petition dated so and so and so and so.
Why should you interfere?
Lordship,
Where is the illegality for interference of this order?
Lordship, firstly, the important witnesses are still there.
That doesn't matter.
Lordship. Secondly, Lordship.
This particular paragraph 10 and 11.
Lordship.
Is not it sufficient? It is not that whenever you feel like you'll appear, you'll pull someone and place it for evidence.
Lordship, we have summoned the witnesses, but none turn out.
So
thereafter, Lordship,
the appellate court considered these aspects 89 dates, and you fail to place any prosecution.
Lordship, but that apart, Lordship,
and that the time cannot be extended like this.
Lordship, there are provisions, Lordship, provisions clear, Lordship, that chief judicial magistrate can further extend the time. The important witnesses, Lordship, the complainant who has lodged the FIR, is yet to be examined. That apart, the IO and the medical officer.
See, basically, it is your duty to close the prosecution witnesses. You have paid to for 89 days continuously.
Lordship, from 23/12/21 is COVID period, Lordship. Period is COVID, Lordship. COVID is going on, Lordship.
On 23rd of December, what? There was no COVID. From 23rd of December 21, there was no COVID.
21st, Lordship. 23rd December 21st. At that period, Lordship, that situation is still prevailing, Lordship.
COVID period.
It was not in a normal state, Lordship. People were. Though in some court, Lordship, this honorable court is directed to take the evidences, Lordship. But the general people, Lordship, they are not coming out.
Please take your seat.
Lordship.
আমার একত্র order, full bench order. এই কিদিনাখন এটা নতুন করে judgment দিলে। Ms. Zahan, that day, Mr. Bhuya or Mr. places judgment regarding the period. We have also dictated the order. I just forgot the period of limitation regarding the COVID-19.
Yes, sir.
Have you
We were
remember?
supposed to see. In fact, the judgment that was placed, Lordship had spoken about a High Court judgment, but he had placed one Supreme Court judgment.
Oh, that's right.
Yeah. That research of the COVID again in
Thereafter,
2020.
that's right. There was a specific observation made by the Honorable Apex Court.
And the
it was
entire period is given.
that three judges went from 2020 March, I think so, or something till.
Yes. I don't remember the citation.
From 15th of March 2020, that I remember, it extended up to
22.
22, some date in 22.
Judgment is well known to everyone.
No, dates were, cut-off dates were there.
It's very. From what to what?
Limitation for the I am not also limitation for
I have not.
I am not solely as in limitation of हमारे against के दिखे
It is pura limitation. It's how we file.
yes telling on limitation
One of my learned friend has given one judgment that is suo moto in recognizance. for
That's right, it should be so moto only.
Yes, this is
From sometimes in 15th of March 2020
Right.
till sometimes in 2022.
the period here given.
Second last paragraph you will get.
Yes, 15/3/2020 till 28/2/2022. In cases where the limitation would.
that
have
is only for
expired,
limitation my lord
No, that
Filing.
matter was discussed in various ways.
28th of February 22.
Mr. Chaudhary, there was a direction also from our head, but the reason is that the regular business of the courts
my lord
were restricted.
Yeah.
And when in the full bench of this court, whereas myself was also part of it, Honorable Justice Julia, as you has done,
my lord.
along with Justice Kotecha Singh, as you has done.
এইটো গুৱাহাটীত হাইকোৰ্টতে আছে 3 বেংক এইটো বাহিৰ নেকি
With effect from 16th of February 2022, the state of Assam courts in physical mode was allowed,
my lord
including the tribunals, special judges, etc.
order step like
But Mr. Haloi,
yes lord
there was no COVID effect on 15th of July 2022 and 27th of July 2022.
lordship I agree lordship but the situation was not like that the general people
You cannot have the benefit all the way like this.
lordship
Hmm? Please come to page number 16. Read it.
Both the CCL are absent with white petition showing cause. Heard, considering the submission where is allowed, the case was switched for PW, but PW has not turned up. On the last occasion, the prosecution side was directed to produce all the remaining witnesses today without fail, but the prosecution side has not been able to produce any witness today. Parallel of the case record reveals that the instant case has been fixed for prosecution witness since 28/11/2013. The prosecution has been given ample opportunity to examine the witness since the year 2013. Accordingly, considering the long pendency of the case, further PW is true. Lordship, on 15/7/2017, as because the tenure of the PP was not there, Lordship, and the process was initiated to extend it.
The next date.
Next day, Lordship, it was not known to us on 21. However, Lordship, on email, I mean to say e-court, we found the date. And on that day, Lordship, we have again filed a petition for examining, for opening the prosecution, which has been declined by the Juvenile Justice Board. 21, Lordship. Both the CCL are present. The case was switched for statement defense of the CCL. Seen the petition on behalf of the prosecution, praying for fixing another long date in the month of September. Hard. Where is the case record? Parallel the case record reveals that in the instant case has been fixed for prosecution witnesses 28/11/2013. Section 14 of the Juvenile Justice Act, Care and Protection Act mandates inquiry to be completed in a period of 4 months, which can be extended for a maximum period of 2 months. Considering the circumstance of the case, the statute provides for maximum period of 6 months to be concluded in an inquiry. Hence, no ground can justify the delay of 9 years. That is observed. According to the prosecution side was directed to produce all the witness on the last occasion without fail, but the prosecution has not been able to produce any PWs on the last occasion, and accordingly, further PW was closed. Hence, I do not deem it justified to allow the prayer of the prosecution. Both the CCL are present and their statement defense has been recorded. The defense is not willing to adduce any evidence. So in these 2 days, Lordship, the PP was not there, Lordship, as because his tenure was already lapsed, Lordship.
Is it the fault of the court? PP was not there.
Lordship, Lordship, difficulty is that in those areas, Lordship.
That's your responsibility.
Lordship.
Is it the responsibility of the court?
Lordship.
If the state is not appointing any public prosecutor, special prosecutor, is up to the state.
Lordship. On similar ground, Lordship, on para 5 of my petition, stated, Lordship, in similar nature of cases, Lordship, prayer is allowed, Lordship. Offense is serious, Lordship.
That's true. But who would stop you from producing prosecution witness?
For appointment of CPs of CBL, it take long time, Lordship. So
that is up to you, Mr. Bhaloi. It has nothing to do with the court.
Considering the gravity of the offense, Lordship.
That's not the way, Mr. Bhaloi.
Witnesses, Lordship.
Taking your own time to appoint a special public prosecutor.
Subsequently, it has been appointed, Lordship. And therefore, Lordship, that appeal has been filed by the special public prosecutor in the month of November, Lordship.
Yes, Mr. Chaudhary.
My lord, since 2013, my lord, this trial was pending, my lord. Occurrence of 2012. And my lord, till my lord, even if we leave aside the, my lord, the COVID period, my lord, till 2020 also, my lord, 7 years has elapsed, my lord. And not a single witness, my lord, they could, my lord, produce before the court. In that circumstances, my lord, they being a juvenile, my lord, can they can be, my lord, their fate may be kept hanging for such a long time, my lord.
Lordship, 7 years, it will be wrong, Lordship. 7 years, we have examined witnesses, only few witnesses remain, Lordship. The IO, the medical evidence, and the complainant.
Where you have stated? Where you have stated?
Lordship may kindly come to page 9, para 3. Para 3, Lordship. For that, some important witnesses, complainant, postmortem doctor, executive measure who conducted inquest, IO have not been examined before the, and they are required to be examined before the so and so in the interest of the case. Only these remains, Lordship.
How many witnesses are there as per the charge sheet
Lordship, statute is not available.
in your record? Mr. Chaudhary, any idea?
No, my lord. But session judge's order, my lord, at page 86, my lord, that reflects that, my lord,
26.
at page 26. Has started since 2013 and as many as 89 days were fixed for prosecution witnesses. It also appears from the record that a statement defense of the accused persons were
There is
discussed.
no mention how many witnesses.
Yes, that is not mentioned.
What happened on those 89 days? How many witnesses were examined? It is not there.
That is not stated.
Mr. Halu, you have also not mentioned how many witnesses have been examined.
Lordship, let me take instruction and come by 2 p.m. Lordship, if Lordship permits. Lordship. I have to take instruction on this point, Lordship. If Lordship please.
How many witnesses are there as per the offense report?
Lordship.
And how many witnesses have been examined?
Lordship.
We'll see to that at least. Mr. Chaudhary, we have that information. as well.
My lord. I will also try to get my.
Yes, yes, yes.
My lord, here in this case, my lord, the petitioner was arrested on 21/11/2022 pursuant to an FIR dated 21/11/2022. While he was arrested, his mobile was seized. And the mobile is not yet released, my lord. And his Zimba petition was rejected by Annexer 5. Lord, you will find at page 24, order dated 9/1/23. The IO is required, my lord, for further investigation. My lord, whether it is still required, my lord, 9/1/23.
Perhaps report is called for on the last occasion, no?
No, no, no.
Acha, acha.
It was called for since long.
Oh. I've sent Miss Das to inquire whether report is there in the office. Report to whom?
It was on August 2023
Oh, it's long back.
and there is a specific order.
Lordship will take it up tomorrow. I'll get the report directly from the OC. Tomorrow, Lordship will take it up.
So this order.
Unless we take personal step, the report never comes. So I'll talk to the OC today. KK Parasha. Learn along with the season.
Just see 22nd August order.
This is 17/7. Acha. Shall obtain instruction from the IO regarding FSL report also. Huh? This is 17/7.
Thereafter, there is another order 22nd of August 2022. 3.
14/5 also, yes, 22nd of 8, 22nd 8. Lordship will request a
Then the
lordship.
last order, last order.
As requested on behalf of sir, let the matter be listed 1 week. And last order also I've seen. In interim, hereby directed to obtain instruction from the IO regarding FSL. Returned after examination or not. Furthermore, if the, yes, Lordship will take it up tomorrow, day after. It's a, 23 pa pending as
On
a
the prayer of MS Khan, an additional public prosecutor
SH Bora was there. PS
placed on.
92, no? 90, Kaki PS. Next second, yeah?
We'll have it on 16th. Mr.
Lordship.
Secretary.
Positively, I'll bring it.
And
Personally.
we'll fix a date. You know the outcome because there is a specific order for personal appearance. The concerned officer.
Lordship,
If it-
92 of 22. 22, na? 92 of 22, Kaki PS. Kaki huna hai na?
List on 16th.
Kaki usi number ka.
Meet your lordship. The dismissal of my complaint under 406 CRPC in provision of 181 subsection 4 is the subject matter in dispute, lordship. Lordship may kindly take of the complaint petition first, lord. Page 20, my lord. Lordship has page 20, my lord. Ah.
Yes.
Page 20, my lord, may take up for a moment. This is the complaint case, my lord.
Hmm.
First, Meenakshi Burman, daughter of so-and-so, wife of so-and-so, resident of Ambenagar, Silpokri, my lord, Kamrup Metro at Guwahati, my lord. She lordship. Fine, my lord. And thereafter, lordship may kindly see the prayer portion, my lord, which is at page number 24, my lord. It is therefore prayed that your honor may be pleased to admit the petition and take cognizance against the accused person for commission of offence under section 406, 506, 34 IPC and punish them for conducting trial against him, and during the pendency of the case proceeding trial issue notice a search warrant against the accused person under section 93 CRPC directing the police to seize the material given in the list of the articles of the complaint petition and from the custody house of the accused person and to hand over the same to the complainant, my lord. Now, lordship may kindly see the order dismissing this petition, lordship. The goods were to be handed over to the complainant, my lord. That was the prayer, my lord, in the petition. Page 27 in the impugned order, my lord. May I read, my lord?
Just a minute. Do you have the petition filed by the petitioner before the court?
Lordship, page 20, my lord, from page
Page?
20 onward. This is the complaint.
Read para 2,
Lord.
the last line.
Lordship, after the complainant started his matrimonial life with her husband at Kanpur in the district of Nagaon.
Para 3,
At the time of the state marriage, the parent and the relatives of the complainant had given various articles ranging from gold jewelry, utensils, so and so list attached, and all the articles were taken to the house of the accused. Were taken, Lordship, to the house of the accused soon after the state marriage and are still under the dominion of the accused.
so what is the illegality? Please come to page number 27.
Lordship, this is the impugn order. Married, Lord. Today was the date fixed for and a complaint is present along with the learned counsel. I have perused the complaint petition, wherein the address of the accused in the district of Nagaon and the Kanpur PS, as per the judgment of the Honorable Guwahati High Court in Rajiv Chakravarti versus Lina Mujumdar in 2020, so and so, it has been laid down by the Honorable High Court. There are cause of action for recovery of certain articles that arise within the local jurisdiction of the magistrate, in whose district the articles were delivered and allegedly returned. Delivered and allegedly returned, Lord. In the instance case, it is prima facie apparent that the certain article has been allegedly delivered and detained in the district of Nagaon under Kanpur PS. In the light of the above discussion on the recent decision of the Honorable Guwahati High Court, and so this court is to consider the opinion that this court does not have the jurisdiction to try the instance case. As such, the complaint directly final copy. Now, before this decision of
Mr. Lal, just tell us one thing. How will you recover that if this particular court allows for the recovery of street and how will you recover it?
It has,
in whose jurisdiction it is?
The case is in the jurisdiction of Nagaon, my lord. There is no. The question is whether this court will have jurisdiction to try the case or not. That will be the question.
Tell us whether it can extend its jurisdiction to Kanpur, Nagaon.
That will
For
not
recovery
be.
of the street and property retained by the
If part of
Tell
the
us
cause of
under the
action
law.
is origin at Guwahati,
Mr. Lal, just show us the provisions where it can be the magistrate at Guwahati can pass an order and it can be recovered from the area of jurisdiction of Kanpur in the district of Nagaon.
One of the Guwahati High Court, my lord, before this judgment, my lord, Justice Amitabh Roy, my lord, 2004, Guwahati High Court, my lord. Now, this judgment of Rajiv Chakravarti has not taken into consideration that judgment, my lord. So it will not be a binding law in my humble submission, my lord. There is a Supreme Court judgment also, my lord, which says so, my lord. We start with the Guwahati High Court, my lord. Paragraph 29, page 15, if you lord. Yet transfer was paid for, my lord. Paragraph 15. Passing was earlier paid for, my lord. That was dismissed. Transfer was also dismissed, my lord. If your lordship takes up, my lord. Lordship has paragraph page 15, my lord. 33 and 34 will be the relevant paragraph. Page 17, para 33 and 34, my lord.
Mr. Lal,
Lordship.
please, for yourself, first read the paragraph. Read para 6.
Para 6, my lord.
Six to 9.
Uh, 6 to 9, my lord. On 110,
You read it
2012.
for yourself.
Lord. One more fact, Lordship. In this case, the divorce was granted by the family court Guwahati, my lord.
No, that was
Page
Different.
11, Lord.
which one?
Page 11, Lord, of my petition. And this order has attained finality, my lord, has not been challenged. Court of the principal is family court number 3, Kamrup Guwahati, my lord. Divorce was granted.
So,
One case in Guwahati, another in Nagaon, my lord. One fact. Second, Lordship is, my lord, what Justice
This was a family.
Honorable
court.
Mr. Justice Roy has held, my lord, in paragraph 33. If you
before
Lordship
that,
take,
look at the paragraph,
Lordship. It says, my lord, that if we impute, read paragraph
read,
181. Lord.
read paragraph 31 and 32
Lordship.
of Justice Roy's judgment.
Lordship. To appreciate rival contention, the complaint, which is the foundation of the criminal procedure, need to be examined. It discloses that some article in marriage were given to the wife as prison, which was taken to her in-laws' house at Guwahati. On 26/4/2022, the husband drove her out by retaining all the belongings as well as the children. Further allegation is that the accused person is the husband and his father, while using her belongings to prison, deprived her of use and enjoyment thereof. They refused to return the same in spite of the request made by her, and are instead preparing to dispose of the same. Incidentally, some of the articles pursuant to the search warrant has been retrieved from the house of the accused person, as marked above. The wife, in high reply, in her it should be high, no, it should be her. In her reply, noticed and made a request to the husband to preserve her belongings and student to refrain from disposing of the same for unlawful gain. The complaint wife and her wishes have supported the allegation made in the complaint. They have categorically stated that not only her belonging and the student have been retained by the accused person, thus depriving her of use and enjoyment thereof, but also are preparing to dispose of those as well. Prima facie, therefore, the offence of criminal breach of trust surfaces from the complaint as well as the initial deposition. Under subsection 4, section 181 says an offence of criminal breach of trust may be inquired into, tried within the local jurisdiction of the offence was committed, or where the property which the subject matter of the offence was received or retained or required to be returned, my lord, or required to be returned. 4th line, my lord, of that lordship has, my lord, are required to be returned or accounted for by the accused person. Now, these few, my lord,
Go ahead.
Lordship,
Read that paragraph 32.
Lordship, under the scheme outlined in chapter 3 of the Code of Criminal Procedure, while offence is ordinary to be inquired into and tried by a court within whose local jurisdiction it was committed, section 178(1) is a contemplated situation where an offence can be tried or inquired into by a court at other places as well. The purpose, in my view, is to provide a legal plea to settle and otherwise permissible criminal prosecution on the objection regarding jurisdiction of the court. The expression was required to be returned or accounted for had come up in consideration of so and so Ahwalia case in the context of a proceeding of a offence of criminal breach of trust launched by the wife against the husband related to the marriage or attempt. It was held herein that in the absence of a stipulation between the parties, the place of prosecution for the offence of criminal breach of trust would be the one where the goods in question were kept in a trust and a breach in respect thereof was committed, the plea raised on behalf of the wife that the prosecution can be lodged at the place of the residence and not where the matrimonial home is located was negated. With utmost respect, it
So
did
it
not.
was negated by the Honorable Apex Court.
Milord, there is judgment of the apex court also, Milord. Third judgment which says, Milord, have taken a different view, Milord. Now, paragraph 33, Milord, this was negated by this court also, Milord. 33 and 34, Milord.
Because in that case, the facts of the case was the house of
No,
the.
Milord. 181 subsection 4 was interpreted in that way, Milord. If I may be allowed to read paragraph 33, Milord, for a moment.
You have read,
33, Lordship.
you have read it, para 33 of Justice Roy's judgment, right?
Lordship. With utmost respect, it is not possible to read concurrence to the above view. Such an interpretation would, in my opinion, restrict the scope and ambit of 181 subsection.
Which Supreme Court judgment you are relying now?
Lord, now the Supreme Court judgment would be, Lord, Kushal Kumar Gupta and another Lord. In this case, Lord, same principle, Lordship. The special leave petition is directed against the judgment and order it is so and so passed by the learned single judge of the Punjab and Haryana High Court, dismissing the petition application under section 482 of the Code of Criminal Procedure for the quashing of the order dated passed by the learned additional section judge Patiala, as also the summoning order dated passed by the learned section Judge Judicial Measures First Class Patiala on so and so. The respondent herein, Mala Gupta, filed a complaint against the petitioner who are the father and mother-in-law under section 406.498A of the Penal Code 1860, herein after report to IPC. On being satisfied that the prima facie case to go to trial has been made out, the learned magistrate issued process against the petitioner. Aggrieved thereby, the petitioner has filed revision petition against the summoning order, which was dismissed on so and so. Therefore, the petitioner has filed application under section 482 CRPC for quashing of the proceeding arising out of the complaint under section so and so. The main ground taken in the said petition was that the court at Patiala had no jurisdiction to entertain the complaint, since no part of cause of action for the same has been originated within its jurisdiction. On a construction of the provision of section 181(4) CRPC, both the learned additional section that Patiala and the High Court dismissed the criminal revision petition number so and so and criminal miscase number so and so, as indicated herein above. The High Court also directed the petitioner application under section 4 of the impugn order so and so. The only point for consideration is whether the learned magistrate at Patiala had the jurisdiction to attend the complaint and to issue summons on the basis of the thereof. The learned counsel for the petitioner contended that both the learned edition system at Patiala and the High Court misconstrued the provision of 181(4) CRPC in holding that the complaint was maintainable as no part of the cause of action has arisen with the jurisdiction of the court at Patiala. It was urged that the respondent complainant had received back all her articles and personal effect, and nothing remained to be handed over to the complainant particular so as to give rise to a cause of action with the jurisdiction of the court of Patiala. The learned counsel urged the complaint was wholly motivated and without the basis and liable to be caused. On the other hand, the learned counsel for the respondent Mala Gupta submitted the complaint itself contained a categorical statement that Dory articles were to be returned at Patiala court, thus attracting the provision of 181 subsection 4. It was also submitted at the stage of taking cognizance, the magistrate was only required to see whether there was any material in the complaint to proceed against the accused, and the learned magistrate has rightly observed that documents produced on behalf of the accused would be considered at the time of trial. In the ultimate analysis, what emerges from the submissions of the parties is that during the trial, the petitioners will have to disprove the complainant's case that part of the cause of action would arise in Patiala where the Dory articles were to be returned to the complaint. As it stands, the complaint does not indicate that a part of the cause of action arose in Patiala, attracting the provisions of 121 CRPC. The High Court has quite rightly observed that on a bare perusal of the complaint, the Patiala court has jurisdiction to entertain the complaint. The decisions cited on behalf of the petitioner are not of much help to the petitioner. In Hamrit Singh Patiala, this court was held that when on investigation it was found that no case of cheating or criminal breach of trust has been made out against the accused, the High Court could have exercised jurisdiction of section 4 and quashed the proceeding. In the said case, the issue was whether a prima facie case had been made out against the accused. The situation in this case is different from the complaint itself makes out a prima facie case to go for trial. So, Hamrit Singh Ahluwalia case was no case was made out. It was that case that was Lordship was referring to in Justice Roy judgment, Lord, it Harmrit Singh Ahluwalia case.
Was
This court
considered.
held that when on the investigation it was found that no case of cheating or criminal breach of trust was made up. Here that is not the question, just like in this case. Here is the question whether this court would have jurisdiction or not, whether 181 subsection 4 would imply or not. So Justice Roy has also held, my lord, the apex court has also held that if part of the cause of action has arisen, my lord, and in Justice Roy judgment, my lord, paragraph 33 and 34, my lord, it says that it will make the provision, my lord, infructuous, because a wife living at Guwahati, it will not be possible to her to go to Nagaon to file a complaint case. So that cannot be the intention of the legislature, my lord. That was
But the
what
subsequent judgment says anything, no? That's why they said
Lordship.
the honorable, the trial could consider that aspect of the magistrate considered that aspect.
No,
of
my
the
lord,
matter.
magistrate only relied on the judgment of the
That
Guwahati
is
High
where issued in the last case.
Lordship. The London magistrate only relied on the judgment of the Guwahati High Court to come to that conclusion, my lord. But the judgment of the Guwahati High Court did not take all these factors into consideration. And the Supreme Court is very clear, my lord. So when there are two different views of the same High Court, my lord, either the matter has to be referred to the larger bench, my lord, or if your lordship agrees with the judgment of the Supreme Court, my lord, then the matter can be settled down, my lord. That is my humble submission, lord. Because 2004, it was the first judgment in law, and that judgment was not considered. 2004. Wait. Even one judgment of the Guwahati High Court, my lord, Dilip Kumar Gupta, Justice A.K. Goswami, my lord, he also held, my lord, that things were kept at Hosai. It was filed in the same district, my lord. It was in the Lamding. Lamding also has a judicial magistrate court, my lord. He said the Lamding court will have jurisdiction in the matter, my lord. He was compelling a wife, my lord, after divorce, my lord, or after separation to go to that native place would be, in my humble submission, my lord, a little hard, my lord, on part of that.
You have also given the other judgment?
Lordship, one more was there, 2020 Supreme Court, my lord. Page number 10.
Read para 20.
Lord.
Para 20.
Para 20, Lord. 90. Yes, Lord. The principle laid down in section 177 to 184 of the code contained in chapter so and so regarding the jurisdiction of the criminal court in inquiry and trial can be summarized in simple terms. Every offence should ordinarily be inquired into and tried by a court in whose local jurisdiction it was committed. the rule in section 177. This expression local jurisdiction found in section 170 as defined in 2J2 mean in relation to a court of a magistrate where means the local area within which the court of the magistrate may exercise all or any of its power under the court. In the case of uncertainty about the place in which the among the several local areas an offence was committed, the court having jurisdiction over any of such local area may inquire or try such offence. Where an offence is committed partly in one area and partly in another, it may be inquired or tried by a court having jurisdiction over such local areas. In the case of a continuing offence which is committed in more local areas than one, it may be inquired or tried by a court having jurisdiction over any of the local areas. When offence consists of several acts done in different local areas, it may be inquired or tried by a court having jurisdiction over any of the such local area, number so and so and so. When something is an offence by reason of an act done, as well as the consequence that ensued, then the offence may be inquired into or tried by a court within whose local jurisdiction either the act was done or the consequence ensued. A consequence ensued. In case where the act is an offence by reason of its relation to any other act which is also an offence, then the first mentioned offence may be inquired or tried by a court in whose local jurisdiction either the act was done. In certain cases, such as dacoity with murder, escaping from the custody, the offence may be inquired into or tried by a court within whose local jurisdiction either the offence was committed or the accused person was found. In the case of an offence of kidnapping or abduction, it may be inquired into or tried by court within whose local jurisdiction a person was kidnapped or conveyed or concealed or detained. The offence of theft, extortion, or robbery may be inquired into or tried by court within whose local jurisdiction the offence was committed or the stolen property was received or retained. An offence of criminal misappropriation or criminal breach of trust may be inquired into or tried by court within whose local jurisdiction the offence was committed or any part of the property was received, retained, or was required to be returned or accounted for by the accused. Similar line, Milord, Justice Roy judgment, Milord. If you Lordship recall, the Justice judgment has come in the similar line, Milord. So this is my humble submission in the matter.
Yes.
Maybe this revision petition against it with dismissal order, just rightly dismiss the suit because the Guwahati criminal court has no jurisdiction as in regarding this matter. I submitted in 2004 8 Supreme Court cases 100. Quashing of proceedings ground lack of jurisdiction of the magistrate concerned to deal with the matter. Complaint filed under section 498A and 406 IPC and section 4 derivation against the husband.
2004.
Yes, 2004. SC cases 100. Husband his relation by the wife at the place C, where she came to stay after leaving her husband's.
Is 100.
100. SSC 100.
SCC or
SSC 100. 2004 8. And directly in this case, the husband and his relation by wife at place C, where she came to stay after leaving her husband's house at place N. All the offences alleged to have taken place at N, said offences not continuing once, no part of cause of action arose at place C. Hence, considering section 17188 CRPC held that magistrate at C had no jurisdiction to deal with the matter and proceeding was complainant given liberty to file complaint in appropriate court. And in paragraph, this was the respondent to wife of the one appellant filed a complaint in the court of the magistrate alleging commissions of offence punishable under section 498A and 406 IPC and section 4 of the Dowry Prohibition Act. The magistrate directed the police to investigate the case. After investigation, the police filed a search sheet. When the matter stood thus, the appellants filed an application under section 482 CRPC before the High Court, alleging that the magistrate concerned had no jurisdiction even to entertain the complaint even if the allegations contained therein were accepted in toto, as no part of the cause of action arose within the jurisdiction of the court concerned. The complaint itself disclosed that after 15/4/97, the respondent left the place N, where she was residing with her appellant husband. and came to the city C. Since all the alleged acts as per the complainant took place at N, the courts at C did not have the jurisdiction to deal with the matter. On the other hand, respondent to submitted that the offences were continuing in terms of section 178A C CRPC, and therefore the court at C had had jurisdiction to deal with the matter. In details, the appellant calls in questions legality of the judgment rendered by the learned single judge of the Madras High Court, this one on it, and respondent to as the complainant file and complain in the court of the magistrate concerned alleging commissions of offence punishable under the section 488-406 Indian Penal Code 1860 and section 4 of the Dairy Prohibition Act. The magistrate directed the police to investigate the above investigation charge sheet was filed by the police. When the matter stood thus, the appellants filed an application under section 42. This 2004. Yes. 2004. 2004. Section 490. Same one. We have one High Court decision. Divorce attorney को petition नहीं मिली है, ऐसे लेकर कते लगा है।
Yes, Miss Jahan. Come 181-4.
Yeah, see, well, the last part of course includes things to be given back, to be returned and accounted for.
Read 181-4 stated.
181-4.
I think the 181-4 will be applicable. And 181-4 has various parts.
Ah,
If we apply that,
returning back is also used there.
no, that's why can you read 181-4?
Yeah, Lord.
Correct.
Any offense of criminal misappropriation or of criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed.
Now go slow.
Yes.
Yes.
Or any part of the property which is the subject matter of the offense was received or retained. That is,
Received or retained.
will be at Nagaon.
Retained at Nagaon. Received at Guwahati.
Received at,
If you go by the complaint,
received.
marriage
Yes.
took place at Guwahati
Marriage took place at Guwahati.
and she was given such gift by
Yes.
at Guwahati.
At Guwahati. But it was finally received there.
Retained. So received or retained.
Retained.
So
That
jurisdiction
interpretation
that
will be there.
received part, as per the complaint, is at Guwahati. And be retained that it is or. Received and retained had have been something different. Received or retained. There are two parts. That's why it's saying. In that
Received
case,
or
if
retained.
you have to interpret a received or retained, that means a part of this thing was received at Guwahati. The Sridhana part.
The first receival is at Guwahati.
So the-
Ultimately, it was taken there and
That is
retained.
different.
Huh.
But it was received or retained. That's why I would say if you read the entire 181-4.
So received, retained, or was required to be returned. That is also there.
Required to be returned.
Of course, these articles are not required to be returned. Only if unusual circumstances come up, then only it will be returned. So it was required to be returned or accounted for by the accused person. No, I think both the places will have jurisdiction. It will come within continued offense. 178.
In that case, the magistrate court at Guwahati shall have the jurisdiction.
It will have this, but my prima facie view is because 178(3) also says it's a continuing offense. A lady comes back from her matrimonial house, stays in her parents' house. And there are judgments also that court will also have jurisdiction as far as 498A or other offenses are concerned. Sweden also 506, this misappropriation will also she'll have this jurisdiction.
One thing is there also, if the articles is taken in from Nagaon, then also how can he receive in Guwahati? But at first we collected the articles from where they belongs.
In that case, the judgment of the apex court will be clear.
Yeah.
In that case, the
As if
accused have to, after taking cognizance, it is the duty of the accused to prove
that
that part is not committed at Guwahati or the place. So straight
thing is
away,
there.
probably the magistrate cannot return the complaint to the complainant that the jurisdiction is not within the said magistrate.
Yeah, High Court judgments I have seen one contention that the other party takes is that there has to be an agreement for returning the article. But in these cases, there cannot be an agreement, it is gone.
That's street and not street.
That is.
But has to
that
be
is
again
different.
proved. It has to be proved.
I think Guwahati will have, Kamrup will have jurisdiction in my humble committee.
cause of action is erosion, Kamrup. This can also be another thing. Cause of action, where is the cause of action? Cause of action is in Kamrup, Kampur.
This is a continuous.
Kampur district, Nagaon district. Na. This can also another thing.
Anything else?
No.
Pardon, Mr. Taylor. Counsel for the petition. NMS J. Colita. Right, counsel
MD
for the NDV. Right, counsel. What's your full name, ma'am?
Morami Dottomiti.
MD. ma'am. Counsel for the- Respondent number one, also what happens at the addition of report. List on 38. For the specific.
38.
Time of this.
May I please, your lordship? In this matter, my lord, I have challenged an order whereby charge has been framed against the petitioner, my lord. Uh, my humble submission is that, my lord, the prosecution projected 10 witnesses, my lord, but none of them has made any allegation against the petitioner, my lord. Even then, the honorable trial court has framed a charge, my lord, against the petitioner. My lord, I have annexed the order, my lord. At page 41, my lord. Here it's mentioned that considering the materials available on record, but actually in the record, whatever the material available has not mentioned anything about the petitioner, my lord.
Take your seat. Yes, Have you gone through the records?
Lordship, yes, no, the 160, those statements he has annexed. From the statement that he has annexed, I don't find the name of this petitioner anywhere in the evidence. And the spectators, the eyewitnesses, they have also stated about 3 persons. One is that Charshit named accused, Sarsong Rongpi. He along with other 2.
Who are those two?
That is the, of course, bone of
That
contention
is
here.
why at this stage, probably 2 persons they have named. Sorry, 1 person they have named, the other 2 persons that they did not name, but
Other 2
there are
persons.
3 persons in the incident. So
Other 2 person complainant has named Inkti and these 2. Complainant has named 2 persons. Complainant has not named about Sarsong. He said Babu Inkti and Hetsing Inkti.
no, that's in the FIR.
That's in the FIR as well as statement of complainant.
He did not see the incident,
He did not see the incident.
but the other persons,
As per eyewitness,
as per other witnesses, 3 persons.
as per other witnesses, 3 persons, they have named only Sarsong, others they have not named. But he said, on the basis of eyewitnesses account, he knew about these 2 persons. But other witnesses have not named those 2 persons. That, of course, goes against him.
His petitioner wife,
Lordship?
petitioner's wife was seen with the deceased prior to the incident.
Acha, that facts are not here. Petitioner's wife was seen.
Because the petitioner did not find her wife, his wife in house. And on being inquired, his daughter said that she went out.
She eloped.
She went out
Acha, acha.
to the market around 11.
Okay.
Then the petitioner in the late evening saw the deceased and his wife together.
Acha,
somewhere in a corner of the market. And then the petitioner with this group of people inquired about his wife. Later in the night was. So that's the story.
But as a matter of fact, his name nowhere appears.
Nobody, these other witnesses in 161 did not mention excepting one name.
So during trial, now if his prayer is allowed also, during trial, if his name comes, then he can be again arraigned as an accused under 319.
Is this other 2 accused persons also not named?
Named by in the FIR and the complainant.
Complainant. One eyewitness says 4, not 3.
4 I have not got. Maybe I've missed. Everyone says 3 people were there. Because page number 27, this complainant says Babu Inkti and Hetsing Inkti. Then Ramesh Inkti says he had simply seen.
Wrong piece. Sarizon Manu. If you read Buddhiram.
Lordship is speaking about which witness? Moina.
He is Buddhiram Rongpi.
Buddhiram Rongpi. Perhaps he has not annexed this. Buddhiram Rongpi. Yes. I went there, saw about 3 persons tussling with 1 person.
4 persons.
3% with 1%. And on asking why they are doing so, one village headman threatened me to leave the place, but I was remained there. Sarsong Rongpi beaten Chhatra through so and so and injured.
It's not the correct translation.
Acha, acha.
Here he specifically mentions চাৰিজনমান মানুহে এজন ছত্ৰবীৰ নামৰ মানুহজনক ঠেলাঠেলি কৰি থকা দেখা পাই দি কোবাই আছিল।
Oh, he wrote 4 persons were tussling with each other. No, I mean, acha.
And when he inquired
Huh.
the concerned Gaumbura threatened him. That part is there, but here he mentioned 4 persons.
Oh, so 4 persons were beating 1 person.
Yeah.
Then in that case, another person will come. His translation is wrong then. চিঞৰ বাখৰ শুনা পাওঁ মই কিনো লিখে উঠি দেখো যে স্কুলত খেলপথাৰত মানুহে 4জনমান মানুহে এজন ছাত্ৰ নামৰ মানুহজনক ঠেলাঠেলি কৰি প্ৰায় আছে here 4 persons.
Yes.
এইটো ট্ৰান্সলেশ্যন ভুল হৈছে মইতো তিনটাই ভাবিছো
It stated 4জন মানুহে এজন ছত্ৰবীৰ নামৰ মানুহজনক It's total 4 persons, my lord.
নহয় নহয় it's only 5 persons then so তুমি 4জনমান মানুহে
এজন ছত্ৰভূষণক মানুহজনক ঠেলাঠেলি কৰি থকা দেখা পায়।
দেখা পায় সেইকাৰণে ৰংপি নামৰ মানুহজনক মোক ৰংপিটোৰ ওচৰৰ পৰা গুচি গ'ল। I think it's including that deceased people.
No, এজন মানুহক চাৰিজনমান মানুহে এজন মানুহক ঠেলাঠেলি কৰে।
But all others is stated, my lord, 3 persons.
No, কৈয়ে গ'ল না
When then, my lord, those witnesses who have been projected only identify 1 person, my lord, not others. But informant mentioned about other 2 persons, my lord. But no one has mentioned about petitioner, my lord.
ইমান নাই ন তাকো সোমাই ল'ব
এজাহাৰত উল্লেখিত পদকীয়া
Two
বাবু
persons and
ইং
another two persons.
এজাহাৰত উল্লেখিত পদকীয়া বাবু ইংটি আৰু হেমসিং ইংটিৰ
No,
লগত
আৰু দুজন।
আন দুজন মানুহ চেৰং ৰংপি আৰু বিমল সিং বে নামৰ বাহিৰে নহয় লাঠিৰে আচ্ছা
বাঁহৰ
লাঠি
লাঠিৰে।
বাঁহৰ লাঠিৰে আৰু
হাতেৰে।
হাতেৰে মাৰধৰ কৰি অচেতন গাড়ীত উঠাই লৈ যায় ঘটনাটো সত্য আচ্ছা there were other two and he includes his name here
The FIR named two accused persons and the two accused persons.
other two one is that Sarsong
Ah.
and the other one he has named here but on what basis this is what this is the entry of the police officer now
Maybe on the basis of that person. There is also statement of this particular accused petition.
Statement of the accused is also there. Gotcha. Yes, so 161, whether he has annexed all, Hemsing Inti,
He mentioned four. Some said three. One said four.
Budhiram Ingti Rongpi says four. Seema Ingtipi says three.
But these accused persons did not, these witnesses did not identify. That part will come later. That was the basis probably on the basis of which four persons were found.
I don't think so. Any TIP and all were also
Was
done.
done and 161 of the accused.
161 of the accused. Bimal Singh Bay.
My lord, the identification parade has conducted by the investigation authority, my lord. Then obviously the eyewitnesses maybe identified that persons, my lord.
That will be a ground for you.
Yes, your lord.
As a defense.
But his statement also shows his involvement. He asks where his wife is and all.
Then he also, but it is 161. But anyway, at this moment only you have to go to the 161 records only.
Yes,
So,
161.
framing of charge.
And 161 can also be of the accused.
So,
any person.
Yes, my lord. Charges has been filed only upon my statement, my lord. But during investigation, when I was in custody, my lord.
Framing of charges, I don't think so. It should interfere here because of these materials.
He নিজেই ক'লে নহয় আৰু আপুনি trial-তে কৰিব লাগিব।
That you may have a ground, it's not at. Just click it.
Lot.
It's loaded to-
এইটো। এটা
Just like
ভালকে দি দিবা।
Mr. MCQ, council appearing for the particular. There is the records of scanned copy of the records of session case number 08/2023. Along with it, records of Scanned copy of the records of the police station case number 103 of 2020. Petitioner herein is aggrieved by the order dated 22/03/2023 passed by learned session judge Kirby Anglong at the Pool. Framing charge under section 302 in sessions case number 08 of 2023 arising out of such the place case number such and such. Against the petitioner and 3 others. On the perusal of the records, it is seen record the statement of the witnesses recorded by the concerned investigating officer in the section 161 chapters. And that of the petitioner. There are sufficient ingredients and materials found pertaining to the involvement of the petitioner. And did not find any such illegality or conformity in framing charge under section 302 of the 32 against the petitioner by the line. The materials in the case report. Doesn't call for any interference of the order is the 22/03/2023 passed by learned session judge Kirby Anglong in six in holding charge or in framing charge of that for exercise of the power under 482. Setting aside the order of the inframing charge to the road.
As far as that JIMA report is concerned, which was in item number 4, one of our colleague had received that report. In fact, it was with him. So many APPs had appeared. So in fact, the JIMA report they had sent, they waited for FSL report. So they could not hand over the articles, that mobile phone. I'll get the updated report.
You have to, in by this time, probably FSL report.
By this time, they must have got.
On 16, it is fixed. So by the time we might have the information.
They will, lot.
Yes, Mr. Sakru.
May I please note it? Hello, Purva?
May I please, Lordship, conducting counsel, Mr. A.W. Oman is unwell today. So we are seeking adjournment for the day only.
Otherwise, my lord, there's nothing to be decided. Only one point, law point is involved, my lord. My lord, the law court, court of SDJM Nazira, my lord, first and maintenance order without following the guidelines of Rajneesh versus Neha judgment, my lord. And that was also availed by the Sessions Court. Now, thing is that, my lord, I have been giving maintenance at the rate of 5,000 out of my own, my lord. That has to be decided, my lord, because without following the guidelines, my lord, even interim maintenance could not have been passed by the honorable court. So
There was no report. There is no report. The man, why just, where is that order?
My lord, that judgment of Sessions, my lord, at page 63. It has only mechanically availed the law court judgment, my lord. 64, my lord, it starts. My lord, may I come to the last portion. Page 73. The Lorded Court, my lord, have resorted to earlier practice, my lord, of considering the, my lord, present scenario of high price, essential commodity, these things, my lord, without directing the parties to file their affidavits of assets and liabilities. From that judgment, my lord, that situation has gone. My humble submission, maybe, my lord, my lordship can, my lord, direct the parties to file their affidavits, my lord, in this proceeding, if my lord decides.
Mr. Rahman is not there well today. We'll
I've
have
seen
it
him
next
here.
week.
No, he's not. Man is.
It is submitted accordingly. Heard Mr. Arthur. And Mr. Kevin. The summit is about the current council by the Mr. A.W. Rahman. And such. Wait for a short accommodate. Mr. Chakraborty, next week?
Or Friday, I mean, if possible. But
Friday, I don't know how many methods will be there. Okay, on Friday.
no, 19 and 20, I will be out of station, my lord.
We'll see you on Friday.
Friday, always.
Deeply very lordships.
That's it. On the last occasion, my lord, the matter of the lower court proceeding has been stayed and notice was issued. But the record was not called for, my lord. So record may be called for. And the respondent number 2, private respondents, the cause list is in the cause list, their names have been shown. So they matter their appearance.
Yes, Ms. Jha, do you have the petition with you?
Yes, yes.
Please
In
come to
fact,
page
what-
number 20, paragraph 8.
Lordship, that, page 20, paragraph 8. That the complainant begs to state that finding no any way she has approached his honorable court for fair trial and justice and for pushing the accused person. This is again 156.3, but
That application is 150. You come to page number, it's very clear from the petition itself.
Huh.
But you will get it at page number 16. First line in the matter.
Yes, under 156.3 for a direction to the officer in charge. But
But
without
there is no
following the,
mention that it was on the basis of any such, she approached the police station first or thereafter. There is nothing like that.
those things are not there. In fact, that point was raised before the JJB at page number 29. That Priyanka Srivastava and all were not followed. But procedural lapse, board said that because since cognizance was already taken, so this procedural lapse will not be fatal.
The cognizance itself is illegal, my lord.
LCR লাগিব জানো? নহয়, ইয়াতেতো এইটোৱে ভুল হৈছে ন? The basis is wrong. চার্জশিট দি দিলে চার্জ পেপার গ'ল, এইপিনে সেইবোৰ হোৱাই নাই।
Yes, ma'am.
In fact, that day we were, Lordship had also
Discussing.
told me about this discussion.
This
I
is-
got one High Court judgment where it is said that if the basis is wrong, the entire subsequent thing falls. Now here, the complaint itself is not maintainable. I mean, this 156.3. So in that case, filing charge sheet, taking cognizance or framing of charges, everything, of course, I didn't get any Supreme Court judgment on that, only on High Court judgment, I'm saying.
Other side haven't appeared, but their names shown.
Huh.
The names have been shown.
Yes. Mr. I. Chaudhary. I'll try to find some more judgments. Lordship can take it up after a few days. But this finding of the JJB that procedural lapse will not matter, perhaps is not proper. And he then again says about the second ground that 494 is not maintainable because the first marriage was not legal. He did not give any finding. He simply said that On perusal of records, I find prima facie material. He did not give any reasons to that.
Heard Mr. Jacobson, counsel appearing for a petitioner. And I'm Mr. Jahan Variation for prosecutor appearing to the state respondent number 1. Do name of two counsels have been reflected in the court list. 2 or 3. But the petitioner remained, sorry, respondent number 2 remain unrepresented. Call for the records of PRC case number AJB 04/2023. 10 copy of it. Legible stamp from the Court of Learned Principal Magistrate, Juvenile Justice. Along with the records of scanned copy of the records of FTPS case number 39/2000. Sir, sit file against how many persons?
Only one, only the against the petitioner only.
List on. In 9th of September. Jurisdictional call for it. 9th of September.
My lord, I will be out of the station on 9th, my lord.
Okay, in that case, second,
Second week, my lord, on September 2nd week, in any day.
2nd of September. 2nd of September.
My lord,
It's,
may continue.
Until further order of report. The interim order passed earlier on 13/12/2023.
All right.
Yes.
My lord, we have challenged verse 51. The impugned order 51.
No, that's true. We have passed an order on last occasion on 29th of July, asking the petitioner as to why that judgment shall not be applicable in your case. You had a deliberation.
No.
Why that judgment of 2014 10 SSC 713 will not be applicable in your case? Tell us.
Judgment applicable. No. Lordship, May 2019. 2014.
You have to tell us, Mr. Mahmood, why that will not be that decision. It will not be applicable in your case.
Which time? Actually, my lord, I'm sorry, I could not follow that.
That is why, because that order was in passed.
Yes.
In compliance of the judgment of the Honorable Apex Court. Right? Why it will not be applicable in your case?
Yes, I last order to say, yes, sir.
You have to tell us.
I understand that, but here, my lord, from another angle, this case is not to be
Why?
taken up for trial, because there is a money suit going on between the same parties but the same subject matter. So that is that's judgment, whether it will be applicable or not, because no person can be punished twice for the same type of offense. And moreover, on earlier occasion, full hard judgment was passed. There was no any preliminary issue was framed, that whether the case on the ground of prematurity is liable to be accepted or not. There was no preliminary issue was framed. Full hard judgment was passed, accused was acquitted. Side by side, there is one issue. Whether both the proceedings, civil as well as criminal, of course, in some cases it is applicable, but when the parties are same, money matter is the same, it is not a kind of harassment upon the present petitioner.
Money suit is for the recovery of the amount.
Yes.
And this is for the bouncing of the check, which you have under 138. There are two different checks now.
The NI Act also, they will get money.
That's a different thing, right?
Rather, he will get double money, double amount.
That is.
In addition to conviction, if proved.
But I think to go through that judgment, I think.
Yes, well, I may go.
You have to.
Actually, I did not go that. I will go definitely. This time I will go and I will satisfy Lordship on this point. That simultaneously two proceedings for the same cause of action, only rare among the rarest cases apply.
कितने अपन कहते मंत्री को 30 no कहते macam yes when Mr. Mahmood tell us when
That will be the first week of September.
second
night. 2-9.
May favor Lordship indulgence, my lord. I am appearing in item number 30, my lord.
30,
my lord. Today, my lord, I am leaving for my lord Jorhat. Can this matter be, my lord, taken up on some other day, my lord?
Have you informed the other side?
I'll inform my lord.
We'll fix a date later.
My lord, I am ready.
And subsequently in the additional search, 20 more witnesses, that is 69 total witnesses. And out of the 69 witnesses, only 11 witnesses were examined.
Since 2000?
13. 14, because supplementary search has been filed on 2014.
If that is the case of progress, then you tell us.
Lordship, my respectful submission, Lordship, offense is very serious.
Might be.
Therefore, last opportunity may be given on at least to examine the important witnesses. Out of the 69, I think all of the witnesses are not important. Therefore, prosecution may be given a chance to at least adduce the evidence of those.
Is it permissible in that manner? That only few should be allowed by the court and the remaining should not be?
No, Lordship, it is a
Then
prerogative
once
of
we allow you, you have to again for the same process.
Lordship. That would be the better solution, Lordship, because offense, Lordship 302 and Lordship, it's a ethical clash between two community, Lordship. 5
Tell us, when did you file this search sheet first?
Search sheet was initially filed.
Do you have the information?
(21/9/2013).
This consists of how many witnesses?
It consists of 50 witnesses, Lordship.
50.
50. 50,
Supplementary
49
search sheet.
witnesses, number 50 is any other witness, 49 witnesses. And in 50, serial number 50, any other witness if required. 49 witnesses.
Then supplementary search sheet.
Supplementary search sheet, Lordship. That's another one. It was filed on 27/8/14. 27/8/14.
Yeah.
Here, Lordship, witness 12 witnesses. 12 witnesses. Additional 12 witnesses were cited as a witness.
How many you have examined till date?
11 witnesses, as per instruction, Lordship.
Yes, Mr. Chaudhary. Not very impressive, but tell us.
61 witnesses total have to be examined. Till now only 11. And my lord, past 7 years, I think about 7 or 8 witnesses were examined. And subsequently in my lord, 22, my lord, after COVID, another 4 witnesses I think examined. So that is the position, my lord. Being the juvenile, my lord, their trial have to be finished, my lord, within a fixed time, my lord.
That's the provision. That is why the question cannot be delayed for such a long period.
My lord.
Mr. Haloi
Lordship.
has been the judgment in the challenge. Learned session judge have considered those aspects.
Regarding the gravity of the offense, Lordship, was not discussed, Lordship. Offense is, Lordship, very serious, Lordship, and not only serious, heinous. What is heinous? It has been defined in the Juvenile Justice Act, Lordship. where the increment of the offense is more than 7 years. Lordship. Here in this case, Lordship 302, 5 persons were killed, Lordship. We found dead, Lordship. Had it been a very petty offense, I would have not prayed, Lordship. The offense is very serious, Lordship. Considering the gravity of the offense, Lordship, and also because there is a provision, Lordship, proviso 14, Lordship, has already been there, Lordship. The further extension of time may be granted, Lordship. Section 14 of the JJB Act, Lordship. Proviso of the Act says, Lordship, it requires, Lordship, in case of serious or heinous offense, the board requires further extension of time for completion, and the same shall be granted by the chief judicial. That aspect is there.
Mr. Chaudhary,
Well,
we're fixing on 19, we'll pass the order.
19th, well.
What, Mr.
Only thing, my lord, for that reason also no application is filed, that it should be finished up, my lord, expeditiously. That proviso, my lord.
The difficulty is that the PP was not there, Lordship. The tenure of the PP expired and it was on process, Lordship. So that cope up the difficulty on passing that order, Lordship.
That's your fault. That cannot be a ground for extending,
I
right?
agree, Lordship. That I agree, Lordship.
I'm hello. For the. And Mr. B.M. Chaudhary. That council for the restaurant number. List on 90. Next. Puno upgrade in the series. Mr. Chaudhary here again, right?
That voice sample case, my lord, may I just pray for, my lord, 1 week's time? Because, my lord, in Supreme Court, my lord, on this point, there are 2 cases are pending, my lord. Vineet Kumar and, my lord, another is, my lord,
Yes.
from the Tamil Nadu, my lord, that case is pending. So those high court judgment, my lord,
After that judgment of the apex court that it cannot be sent.
Yeah.
Because the evidence is only to that part. It is not there in the CRPC.
Yeah.
That
Not
was
there in the
judgment passed by Justice Gogoi, right?
Yeah, yes.
Or Ritesh Kumar. that-
Ritesh Kumar. So thereafter, there was no such provision for giving any such direction for giving a recording of voice sample, now which is pending before the apex. But it was not, I was looking at it on that day, but thing was this, by which it was referred, that issue was not, I didn't get that judgment.
This request in, my lord, that issue was not discussed because that point was not raised by the council, my lord.
No, but in Ritesh Sinha, the whole Justice Gogoi's judgment,
Yeah.
you see, there it is, this, that fact is that CRPC doesn't provide for
Yes, so,
recording of any such.
so legislation
So there
should pass
cannot
such
be-
a order in
But,
future.
yes.
But this is only in the new Adhiniam, right?
My
It is not there in the CRPC.
That time
So
it
what
was
will-
not there.
Otherwise, under the CRPC, it cannot be extended.
Yes, no provision in CRPC, but Ritesh.
Obviously.
But then it is said it will not violate Article 20, Clause 3. And so this is what I think the present position is.
That is different, but at this particular case,
Huh.
that is why in the new Adhiniam, it has been incorporated.
Acha.
New 3 criminal laws, that provision is there.
Oh, for
New
giving
act it
voice
is
and-
there, new act.
Oh,
New
I
act
have
is
not
there.
gone through.
Yes.
Asa, no? Voice and-
New act it is there.
Hmm.
But in the, this is a case.
Oh,
So. very
But
clear.
again, as a procedure, Lordship can take into account a new act. Procedural law, it need not be prospective.
It was there. ভবন হয় বলে আছে।
সেইটো আছে।
Savings clause আছে last one.
Oh, savings clause.
Saving clause, is there, that day, last day we have seen it.
Acha, acha, acha.
It is there in the saving clause. Whatever is there will not be included.
Oh, নতুন একাউন্ট আছে?
523 the last section plus.
It is there.
Oh, হয় নাকি? It will be carried under CRPC.
That will repeal.
Yes, yes. The proceeding.
531, my lord,
Yes,
section 531.
আচ্ছা, আচ্ছা।
you have shown us on that day.
Acha, if immediately before the date on which Sanhita comes in to raise any appeal, so and so inquiry is pending, not disposed, shall be disposed in accordance with the provision CRPC. Acha, so that will not come. I thought procedural law can be taken care of.
Okay, try to find out.
Yes, my lord, let
About
me
the-
go through those, my lord, high court judgment, my lord, but by one judgment, my lord, it was allowed. And another judgment, it was disallowed. And both the matters are tagged together in the Supreme Court, and that is, my lord, for hearing.
But
One
so
is
many high courts I've seen, they have allowed voice
CBI
samples to
versus
be
Vinit
taken.
Kumar is one case, my lord, and another is Sanjay Bandari versus Union of India. These are the two cases, my lord, which are tagged together, and both of them are pending as on today.
Where the issue involved in those judgment relates to any of the high court, whereby it was allowed.
Yes.
Recording of voice sample was allowed.
One is allowed, my lord, another is disallowed.
Both are pending.
And both, my lord, it has approached Supreme Court, my lord. Both are pending, and whatever we have
Okay.
seen in the, my lord, net.
Because in Ritesh Sinha also, I think the Honorable Supreme Court said, in a way, it can infringe Article 20, Clause 3, in a way. But then,
Without discussing anything, my lord, passing remark was made, my lord.
yes,
Whether that could be done or not, my lord, because that
No, we are here for recording of voice sample. We will go to that extent.
my lord.
Now, whether we should allow or not to allow. Since there is no provision, question of allowing doesn't arise.
Hmm.
Straight here.
Hmm.
But since the matter is subjudice before the Honorable Apex Court and the regard to the issue of this,
Hmm.
and that also relates to CRPC.
Ah.
So, but can you wait till long?
We'll
That
wait
is,
for
my
some
lord,
more time.
It is not reflected, my lord, when the
That's
next date is, my lord.
Okay, you inquire, Mr. Chaudhary, instead of week, we'll give it to 2 weeks. So we can have it in the first week of September.
My lord, my lord,
That will be better.
my lord.
Ms. Zan, you also try it out.
Hmm.
We'll have it on 6th. 6th
Last
of
of
September.
September. I am obliged, your worship.
Interim to be continued.
Huh?
Recording for the question. Petition.
Tricky বস্তু তো, এইটো Ritesh Sinha যেনেকে says story চলে, discussion বাঢ়িলে।
They say he can be a witness, he can be a witness, but he doesn't mean he'll be a witness against himself. They to differentiate কৰি পেলাই থৈ দিলে।
সে details ত নগ'ল।
Until further.
Pending before the Honorable Apex Court. Such already. Second complaint, prayer law placed on 6th.
Interim to continue until further.
My lord, whether on the last date, my lord, interim was continued until further order, my lord.
So I think so. Next date of listing. It will be next date of listing. To dispose it of.
Interim will be continued, my lord.
Till the next date.
I am obliged, your worship.
May it please your lordship. Lordship, my senior, Mr. A. Saman, due to some personal difficulties, he could not appear before this court today. Can you adjourn it for the day?
Adjournment.
What's your good name? What's your?
And Leka. Information, no.
If you
Time to listen.
Time to let.
Well.
Agitate.
Where is it?
কৃষ্ণ কপি এটা ফার্নিশ করতে কপি এটা লাগিয়েছিলাম
Mr. Bora,
My lord.
petitioner is seeking some time.
My lord, my lord. I don't have any objection because
There's no order for any interim orders also? Only, my lord, I do not have that copy, my lord. Can you, I'll request him to furnish a copy to me, my lord. And Mr. P. Bora, Planet Senior, assisted by
K. Bhattacharya.
Council for the
Correspondent number two.
correspondent number 2. Correspondent number 2, my lord. Must be that really in that position of the parameter data list of the 2 weeks on a date. After 2 weeks on a date. Yes, sir.
May please, Your Lordship. Here in this case, Your Lordship, one additional affidavit is required. There are one issue have been left out in my latest affidavit. So I beg to mention for 1 week time, in the meantime, if being filed by affidavit, the CBI can also file the exchange affidavit. There is an urgency, Your Lordship. While I prepared for argument of the case, I found that what point is left out.
On the pair of Dr. B. N. Gogoi, counsel appearing for the petition. Material that done for the
ফাইল কৰিছা তো তোমালোকে না এটা পইণ্ট থাকি গ'ল নকৰিলো নেক্সট নকৰিলো এই মনীষ দৈমাৰীৰ কেছটো
PN.
Yes, deeply applied.
Made, please, Your Lordship. Yes, Mr. Lordship, this appeal against conviction, Lordship, in this case, Lordship, appellant has been convicted under 376 and punishment for 8 years, Lordship. Now, this is statutory appeal, Lordship, may pay for the call for the appeal may be admitted and call for the LCR, Lordship.
Heard Mr. B. Chaudhary, counsel appearing for the appellant. Also heard MS and that's when it's in the by the interim judgment. 2005-2024 passed by learned assistant session judge Bongaigaon. In sessions case number 80 within bracket and capital M bracket 2022. Arising out of Manipur case number 178 of the 202. Corresponding to GR case number 662 of the 202. Convicted the appellant under section 376 of the 506 IPC. And sentenced him to rigorous imprisonment for 8 years with fine of rupees 10,000 under section 376 IPC in default to pay the fine to undergo simple imprisonment for another period of 6 months. And further sentencing for rigorous imprisonment for 3 months under section 506 IPC, where both the sentences are concurrently, and the period of detention already underwent by him. Set of bully, set of fear. Agree with the said judgment of conviction and sentence that is such and such. Noted above, the appellant has preferred this appeal. Sentence is appeal is against admit this criminal appeal. This admit is specifically appeal for the right. All for the records. Already. On the photo card. 376.
Yes, Lordship.
Victim informant not party.
Lordship, in 376, may not
Recorded
require
now.
Lordship.
POXO, Lordship.
POXO is required. Lordship.
The bail of the appellant shall be considered only after receipt of the relevant records from the planet trial list of
Lordship, there is a IA for suspension.
that
of
will be
this.
considered only after receipt of the records.
High level.
And a complete the appellant has carried into same shall be considered on the
The revision petition has been prepared, my lord, challenging the interim order dated 18/4/2023, my lord. By which the, my lord, appeal has been dismissed, my lord, preferred by the petitioner, my lord. And further directed the petitioner to clear up the area maintenance of rupees, my lord, with a fine of rupees 10,000.
My lord, no copy has been served, my lord, after condoning the delay, my lord.
Oh, sir. I will serve the copy, my lord. Like the dispute between the husband and wife, my lord, they will. Mediation, copy to DNA.
mediation.
Mediation.
Yeah, I have to receive instruction, my lord. Then, my lord.
That will be
Mr. Assistant Counsel appearing for the petition. And Mr. B. Sharma, the additional public prosecutor. Okay. That's it. Respondent number. Also heard Mr. K.R. Land Council appearing for the respondent number 2. When?
After a week, my lord.
Serve him a copy.
Yes, today itself.
On the prayer of the council for the party. List on 21st.
My lord.
For mediation,
My
let the instruct.
Yes.
The parties.
Yes, oblige. Oblige.
Please, your lordship.
Yes.
Item 17. Lordship, my apologies, lordship. I was late. Yes, this is an appeal against equity, lordship. It's come up for the first time in a case. The leave was granted. I believe the notice will go to the sole respondent.
Heard Mr. V. H. Chaudhary, that council appearing for the appellant. This appeal is against the judgment dated 29/05/2024. Caused by Planet Additional Session Judge within the FTC number 3 commitment to poverty. Common judgment. In all the cases, the respondent number one was the sole respondent was the accused.
Yes, Lordship.
In all the appeals.
Yes, Lordship. This is only one appeal, Lordship, but it was a common order, Lordship, between the same parties.
Whereby the accused respondent number one, the accused sole respondent was acquitted under the offense of 138.
Lordship. Initially, it was in our favor, but the appellate court set aside the order.
Okay, and I. Setting aside the judgment and orders dated 24/04/2019 passed by the Judicial Magistrate First Class Kamruk Guwahati in share case numbers 612-2013, 961-2013, not 612-2013, 861-2013, 862-2013, 961-2013, and 1138-2013, by which the respondent was convicted under section 138 of the Act. So notice returnable by 4 weeks. States by recommended. Raise the possibility. Providing honor before it. 16. Providing his character for it to check it with the police. All for the records of right from the court of law. List according.
Highly obliged, Lordship.
May I please, Lordship, can the matter be passable for the day, Your Lordship? The engaged counsel is out of station, Your Lordship.
On declare the counsel for the petition list on 16th.
Maybe the Lordship. But if you didn't get it on against the execution is order dated by 28/6. Lordship will find it at next outside Madam, case 43.
नहीं नहीं मैं मुकुल नहीं
Then, madam, as per the last order, madam, order dated 11/7. Passed by this court, madam. And there is an order. Now, in order to inform the court about the plan, how the petitioner would pay the maintenance amount. So, madam, we have started checking everything today. We have made a scheduled payment, madam. How the payment will be made.
Yes, Mr. Das. How much you have paid and how much you are going to pay?
Yes, madam. Till now, madam, we have paid an amount of rupees 1,72,000, madam.
No, Lordship. Absolutely incorrect statement, Your Lordship.
That's it, that, madam, transferring amount, Lordship will, use page number 83 or not, madam.
Okay, towards maintenance, how much you have paid?
Madam, this amount has been paid as per the order, madam, of the, madam, when the case is pending before the family court, madam. We have paid, madam, Lordship may come at page 80. Page 80, madam, paragraph 4, madam.
Yes.
Where the Honorable Petitioner begs to state that till now an amount of rupees 1,72,000 has been paid to the applicant on different dates apart from rupees 7 lakhs. Which was paid to the respondent as per the judgment of the division bench, madam. And the payment which are made on different dates are as follows from 4/2019 up to 25/4/2024. These are the amounts which have been paid by us, but totally to rupees 1,72,000, madam. And the money receipts are at page number 83 or not, madam.
Yes, Mr. Chaudhary. Have you received the copy?
Lordship, I've also filed my affidavit.
No.
Yes, I filed I've got the copy, Lordship. The statements made therein are absolutely incorrect. I will just apprise you, Lordship, of the facts of the case. I'm not blaming my friend because my learned friend has just entered appearance in this matter. This gentleman has managed to change about 10 different advocates in the process of the last 8 years since we've been dealing with this entire matter. So I don't blame my friend for making statements which are absolutely incorrect. There are 3 different proceedings, Your Lordships. One is the matrimonial appeal, which is pending before this honorable court. Another one, the 1,72,000 which my learned friend is alleging to pay me, that is in terms of an order which was passed in the year 2016 in an application under section 24 of the Hindu Marriage Act, Your Lordships. Now that is a separate proceeding, finished, over. And yes, I'm not disputing that he has paid me this 1,72,000, but the order was of 2016. Your Lordships will find that he has himself said that he started paying in 2019 because for the first 2 years he did not pay me. Thereafter, he filed a review petition before the court. When that got rejected, only thereafter, when I filed a contempt in this court, did he start paying me that measly 2,000 rupees of payment, Your Lordships. Now, that is a closed chapter. In the meanwhile, Your Lordships are aware that under section 125 of the CRPC, I am entitled to file a second separate maintenance case, which I had filed way back in the year 2016 itself. Now, the family court, in its own wisdom, had kept it in abeyance at that particular point of time and reopened the matter when this entire divorce petition was being finalized. In that proceeding, under 125, now an order has been made wherein he has been told to pay me an amount of approximately 10,000 rupees per month from the date of inception of the case. Why? Because as per the judgment of Rajneesh versus Neha, he is required to pay me from the date when my matter was filed before the Honorable Family Court. In terms of that law, the Honorable Family Court has passed that order. He has challenged that main order by way of another criminal revision.
Therein, your lordships, his prayer for stay has been rejected. I'm just placing that order before your lordships. That matter has also been heard at length by some other advocate. And I'm just placing that order before your lordships. That entire, after hearing the entire matter at length, this honorable court has been pleased to reject his prayer for stay of the order passed in the proceeding. Now, when I have filed for an execution proceeding, he's now again coming in a criminal revision saying that you stay the execution proceeding. And he's coming up with a schedule that he will pay me in the next 5 years. And the matrimonial appeal, the 7 lakhs, your lordship, the matrimonial appeal was admitted. Even that order I can place before your lordships. The matrimonial appeal itself was admitted on the ground that he will pay me 7 lakhs as the base amount. Only then the matter would be admitted by this honorable court. This man has made me run from pillar to post in the last 8 years, your lordships. I have gone from, I do not know how many litigations. In my affidavit, if your lordships will kindly take up my affidavit, which I have filed on 2/8/2024.
Just a minute.
Lordships. हाँ? पूरा जैसे कि मैंने बना के रखा है.
Yes, Mr. Das.
Yes, madam. Not as far as this, madam. One thing is that, madam, we have at least, madam, admitted that we have received their 1 lakh.
That is a different proceeding, your lordships. Why is one trying to confuse this?
Yes, madam. That
I do not understand. I've just made it very clear. Please don't make the same statements over and over again.
But as far as this, there are 128 says, madam. May I read, madam? Given online, madam.
Lordship, just one small submission before my learned friend starts. In fact, the execution petition is listed before the Honorable Family Court today. His juniors, my juniors are all waiting there because of this particular matter, trying to figure out what is to be done. The Honorable Family Court had told us that you just wait and see the computation, whatever is put before the court, and whatever order comes from the court, accordingly we will decide. I just wanted to apprise your lordships about that fact.
This IA is in relating to which matter?
IA, Your Lordships, there is no IA in this particular
no.
matter. I believe there's no IA, Your Lordships. Oh, the judgment which I produced for Your Lordships, that was in respect of the main judgment which was passed in this particular matter, where I have filed for execution. That is against the order dated 29/2023. That was the order in the proceeding, which my learned friend has not annexed. Has he? Give me an excuse. It is there. It's there, Your Lordships. Page number 15 of the petition. Page one. It starts at page 15, and the effective portion is at page 27.
Okay.
So he has challenged this order by way of another criminal revision, wherein he had filed that IA. And the IA has the stay on that prayer has been summarily rejected by this honorable court. After the rejection, Your Lordships, I had filed the execution petition. And in the execution petition, the instant criminal revision has been filed by my learned friend.
Yes, Mr. Das,
Yes,
there
madam.
what is the illegality?
Madam, Lordship may kindly produce only one line of his judgment.
Yes.
Only one line, madam. 28, 128.
क्या है पढ़ देते मुझे भी
Tell us the citation will be
Yes,
here.
ma'am.
We have the citation judgment.
Rajesh, madam. Madam, I have marked it, madam. Just one line, madam.
लाया क्या रजनीश versus नेहा नहीं लाया ना हाँ, भूल
Which
गया ना।
para? Which parameter?
Madam, I have marked it, madam. 128, 1. Where successive claims of maintenance are made by a party under defined schedule, the court would consider the adjustment or set off of the amount awarded in the previous proceedings, while determining whether any further amount is to be awarded in the subsequent proceedings. That has not been done in this case, madam.
He has not challenged
amount,
that.
which amount I have paid, that has to be calculated, madam, now.
Lordships, he has not challenged. He's not even challenged that. How can he make a submission like this? He has not even challenged that particular judgment. That
And my
criminal
lord,
provision is still pending. His stay is finished. His stay prayer has been rejected.
and my lord, in my second additional affidavit, I have admitted that I will pay as per the earlier order of the court. So, my lord, I have made a schedule. And before this, my lord, on last month, I paid rupees 7 lakhs rupees. So, my lord, she is not on any financial constraints there, my lord. That she will face some financial constraint, my lord. I have prepared a schedule, my lord, how I can make the payment. I am not running out, my lord. But I will not pay. I will pay, my lord. If since the order has been passed, I have to pay, my lord. By this way or that way. And the main cause of filing this criminal division, my lord, was there, my lord, that the family court, the execution court was supposed to, my lord, was trying to issue a distress warrant against me. On that ground, my lord, I appear before this honorable court, my lord.
Just tell us, Mr. Das,
My lord.
in which particular case, how much you have paid?
Till today, my lord. I have given the schedule, my lord. The lordship may kindly.
In this proceeding, nothing.
Because there are two proceedings.
Three, Lordships, three.
One is 125,
Yes.
maintenance is there.
And one is 120.
There, so you are supposed to pay 10,000 per month.
Per month.
Till you pay the permanent element.
Yes, madam.
You have, how much amount you have paid towards permanent element?
7 lakhs, madam. On last month.
Out of 20 lakh.
Yes, madam.
Yes.
And as such, madam, the order has been stayed, madam. But the division bench, madam.
That is subject to the payment of
Madam, I
7
paid,
lakhs.
madam.
Yes,
I
correct.
paid, madam.
That has been.
She has received on last
Yes.
month, madam.
Fine. And then what about the other matter, Ms. Chaudhary?
That has come to a lapse, Your Lordships, in terms of the order. The 2,000 rupees was up till August 2023. So he does not have to pay anything after that in that 2,000 proceeding. Because 24 is an interim, always an interim compensation. As long as the proceeding was going on, it was going on.
Question doesn't
Now,
arise.
so
Final
from
order has been passed.
So therefore, that has stopped now. So till September 2023, he was required to pay me the 2,000 rupees. Since then, naturally, that has come to a lapse. And thereafter, this 10,000 rupees will take effect from the day I had filed the petition, Your Lordships, in terms of the order. Now, he has challenged the order, but the order has not been stayed by this honorable court. So naturally, I have filed for an execution.
this
The
doc-
execution has also not been stayed by this honorable court till date. And your lordships, if I may just point out two things, to your lordships. In my affidavit, if your lordship will just take up the affidavit which I have filed on 2/8/2024. I have detailed it at page number 59, running page 59, your lordships. Paragraph 14, 1/4.
Yes,
Have your lordships got it?
yes.
Besides the above cases, now these are all the cases which I have just enumerated to your lordships. The list of other cases which have been filed by the petitioner against the respondent are given below. Number 1, money suit case number 362 of 2005 to 15 before the civil judge 2 seeking compensation and damages to the tune of 1 crore. He has filed this against me. Since the respondent, because I had filed an FIR against him. This is one case, still pending. CR case number 1755 of 2015 before the SDJM Sadar 2, a criminal defamation against the respondent, praying for punishment to her for filing the FIR dated so and so. The respondent thereafter we had approached the Honorable Guwahati High Court. The High Court has sent it back for the trial, your lordships. Money suit number 59 of 2021. Before the senior civil judge 1, the appellant has filed this case pursuant to his acquittal in the GR case for malicious prosecution of the respondent and further claiming damages to the tune of 1 crore 3,000. These are only the number of cases he has filed against me. Now, his own, I'm just producing before your lordships, his own assets and liabilities based on which the order was passed by the Honorable Family Court. I'm just placing it before your lordships. He's talking about not having money, lordships. Lordships, can you take page 37 of this bunch? These are all documents which have been produced as records by him before the Honorable Family Court, your lordships. Page 37 for a moment. Lordships will find towards the center of the page, there's an Axis Mutual Fund, 5 lakhs. Birla Mutual Fund, 2 lakhs. And towards the beginning of the page, there's an Axis Blue Chip, 1 lakh. And these investments, 15 lakhs. Next page, also page 38. There's an Axis Mutual Fund, 1,50,000. So one more page I would like to draw your lordship's attention. Page 98 of this bunch. The first, second, third entry, your lordships, of this page 98. Have your lordships got it? Axis Bank. Third entry, 14/10/2022. I don't know whether your lordships are aware, there are these shoes which are available, which are called Air Jordans. They are a specific brand of that Jordan, the person who plays basketball. And these are Adidas shoes of valuation 2 lakhs. And not one. He's bought 2 pairs. He's bought 2 pairs, your lordships. 1, 2, 3, 4. 4 entries right there. One, it had reverted. Then again, he has paid one. At one point of time, he's paid 3 lakhs. One point of time, he's paid 2 lakhs. And this was the clinching factor insofar as the family court was concerned when the hearing was going on. Looking into his accounts, he has made me run from pillar to post for 2,000 rupees a month, your lordships. Is it a joke? He's taking the judicial process as a complete mockery. There is a limit to which a woman can be made to suffer. Lordships, I'm praying that this criminal revision should be dismissed in limine and the execution proceeding should be allowed to be proceeded as per law, your lordships. That is my humble prayer before your lordships.
Mr. Das, are you aware of this SHN liability?
Well, I'm aware, madam. I'm aware of this, madam. These are the life insurance, madam. This is the total amount, my lord. Some issue, it will be issue after 15 years, 20 years. It is not a point here, madam. And before your lordship, with a prayer that since I have paid an amount of rupees 7 lakhs on last month, my lord. So some time may be given. I cannot pay, my lord. I am a dentist.
Issue.
Well, I am a dentist by profession, my lord.
Basically, That is an issue where you've been directed to pay 20 lakhs of alimony. Once you pay, you are free from maintenance.
Yes, no, I will pay, my lord. But regarding
See,
this one, my lord,
See, how the respondent will survive because you are supposed to maintain her.
my lord, she is also earning, my lord. And my lord, it is not that she is not getting any money. Last month I paid 7 lakhs rupees. 7 lakhs, my lord. Not in
That's a part of her permanent
Yes,
element.
no, I will pay, my lord. Even
You cannot compare with the maintenance part.
Yes, I will pay, my lord. And regarding the amount which I have paid now, that has to be adjusted, my lord. The Supreme Court also says in a different case.
That is adjusted. You cannot have equate alimony and the maintenance.
Now, here also.
It is not the case of the Honorable Apex Court that you should equate the alimony and maintenance. It has not been stated.
Hello.
Right?
Yes, Lord. That was overlooked, my lord. Subsequently, it came to our notice, my lord, that two claims cannot be made together. There must be some adjustment.
Adjustment, that is why the judgment has been passed that maintenance of 10,000 has to be paid from the date of the filing.
Yes, madam.
During the pendency, you pay the interim maintenance of 2,000.
Yes, madam. The amount which I have paid in the proceeding, madam, that has to be adjusted now while giving the monthly alimony.
Since you can pay 7 lakhs, you can pay also 10,000. What is the difficulty?
I will pay, my lord. That's why I'm
The
saying.
10,000 is from there, Your Worship. Now it has become a lot of problem is arising because it is now
It has become.
arrears have become high. That's
the
all.
order was passed on 2023, my lord.
So he can pay at least 50%. He can at least pay. All he has to do is just take away one mutual fund. That's all. One mutual fund and I'm done. And if he takes away two, the entire thing comes.
What is the total area?
About 8 lakhs something, Your Worship. I have given that computation in my affidavit.
As per my calculation, my lord, now it is, my lord, 8 lakhs 58,000, my lord.
No, Lordship, that is incorrect again. I have given the computation.
You have been with entire 7 lakhs? Earlier, out of 7 lakhs, 5 lakhs was paid to you.
Yes, initially 5 lakhs, then thereafter 2 lakhs.
7 lakhs was paid, my lord.
Page 56. Also, page 56 of the affidavit. I have given the computation, very simple computation, Your Lordships. I have filed it in June 2016. June 2016 to June 2024 is 8 years, clear. So 10,000 per month is 1,20,000 per year. So where is the question of 8 lakhs 30,000? 9 lakhs 80,000 to वैसे ही हो गया. The computation is very simple, page 56. And then there's a cost of proceeding as well.
So according to you, Ms. Chaudhary, it is 9,30,000.
9,70,000. 30,000 he has paid me because that day on the last occasion, the family court made him stand there and do an online banking transfer that you pay at least something today. So that's why he just stood there and transferred 30,000 to my account. It was literally a force. Like the court had to apply literally a force on him that you have to pay. This is an execution proceeding. And since you don't have a stay in the matter, you have to pay this amount. So he paid me 30,000 that day. So the balance is 9,70,000 euros as of date, month of August.
Out of this, how much you have received?
Nothing, 30,000 euros.
That's whatever earlier paid.
No, the 2,000 has lapsed, Your Lordships. 2,000 rupees lapsed in September 23.
Okay.
So I'm not even talking about the 2,000 rupees. Till I think he had paid me till about May 2023, insofar as the rupees 2,000 is concerned. Insofar as this is concerned, naturally nothing, because this judgment itself has come in the month of September 23. So thereafter, he has paid me 30,000 in this proceeding. And he owes me 9,70,000. And on the last occasion, the learned family court had given him as a last chance a month's time to clear the entire dues. And that is when he filed this criminal revision, Your Lordships, praying for a stay of the order.
pay 50% of the area and regular 10,000. Will consider to state it.
Madam,
You pay 50% of the area
madam,
and regular 10,000 maintenance. Will think of staying the execution.
let me give a call, madam. They have to be in the position to pay, madam.
Give him 5 lakh, give her 5 lakhs and 10,000 maintenance per month. Will stay the execution.
Lordship may dispose it in that direction also, madam. We will pay.
After
Before
that,
the, said it
come
would be,
back to us at book of it.
madam.
That will
Let him take instructions. I have no problem. I am at your lordship's mercy. Lordship, say if your lordships will.
pay her 50% of the total area. And the
arrear is not 8,30,000. The arrear is 9,70,000. Let that be clear at least. Because he's taking away a lakh just like that.
Supreme Court is
5 lakhs you pay.
Madam.
5 lakhs you pay her for towards the area amount and 10,000
Lordship,
regular.
But then in that case, in at least some time frame, because then
It has to be. We are giving any
Lordship,
regularly,
but then lordship, then that would be another so many years to come. That would become very difficult, and especially the alum in the matrimonial appeal.
First 7 days, first week of the
every 7 days.
the first 7 days of the next already.
Lordship, the time frame will be fixed for that as
7
well.
days.
For the what I meant was for the balance amount, instead of just giving him an open-handed this thing.
Not disposing of the matter.
Lordship, then I'm absolutely yes.
We'll give him 10 days time.
Lordship.
To deposit the 5 lakhs rupees in your account.
Let him take instruction, Your Lordship. I will just come back. We'll come back. 315. Lordships. Oblige.
Lordship, this is a criminal revision petition, Lordship, revision against convictions. And the petitioner is convicted under section 324, Lordship. Today is the first day, Lordship.
Mr. Sharma, have you gone through the judgment? Have you gone through the judgment?
No, my lord.
Against conviction of under section
324.
for 3 months, simple imprisonment. And acquittal under section 341. What's your good name?
Edas, Lordship.
Pardon, sir. Council appearing for the and Mr. P. Sharma is the secretary appearing. Yes. Welcome. The judgment dated 29/09/2023. The London Chief Judicial Magistrate Karmari in PRC case number 1298/2019 arising out of Kolegaon case number 75 of 2019. Corresponding to their case number 927 of 2019. Convicted the petitioner under section 324 IPC and sentenced him to undergo simple imprisonment for a term of 6 months with fine of rupees 3,000 in default of payment of fine to undergo simple imprisonment for a period of 1 month. Acquitting him under acquitting him the offense under section 341 IPC. Agree to receive judgment, conviction and sentence. The such and such was well added to the judicial magistrate. Okay. The petitioner filed an appeal before the Lancaster Judge of Dalbury, being criminal appeal number 22 of 2022, which was dismissed by judgment 1809 2020. I agree with the same. The petitioner has preferred this revision petition. Made this civilian petition for hearing. Call for the record of presence. As well as the record of presence. Good. Is this matter immediately for our audience. Only subject to but I on the petition shall be considered. You are on bail.
Your lordship.
What you have mentioned that you're in previous bail. Have you mentioned where is it? You have not mentioned.
Mention in the petition, lordship.
So you have not even stated so. The interim application of the petitioner shall be considered after receipt of the relevant reports.
Number 19.
Madam, I have taken the instruction, madam. He was trying, madam. Or here, pay before the lordship, he will deposit 4 lakhs rupees within 2 weeks and 1 lakh after 1 month. After 1 month.
No, no.
1 month, after 1 month.
1 month, we are at least 15 days.
Lordship may
We
pass.
are 5 lakhs and then 10,000 will clarify.
My lordship may pass order, my lord. Lordship may pass.
5 lakhs, your lordship.
5 lakhs.
Lordship.
Well, I'm also on 5 lakhs, madam.
Today's
But he said, madam, that he prayed before the lordship to fix 4 lakhs rupees within
No, lordship, not
2
4.
weeks and madam, 1 lakh rupees after 1 month, madam.
No, lordship.
That was his prayer, madam. I'm just
He can try
conveying
selling his
his-
other shoe, your lordship, on a lighter note.
those shoes have become old, madam.
Still, they'll still can bring you 1 lakh. Lordship, some relief to her, your lordship. That's my only prayer before her. Because he's been making her run from pillar to post for every proceeding, your lordships.
Filing false affair against me.
Huh?
So I have
This is a-
acquitted my lord. And I have taken all the due course of law, madam. Nothing adverse, madam. What to do?
Okay. We'll deposit 5 lakhs of rupees in her account by demand draft or whatever,
He does an online transfer. Normally, he does an online transfer.
or online
is-
transfer,
Lordship.
both process. On or before 38.
My lord, obliged, madam.
And your lordship may kindly be fixed, please to fix the matter sometime in the first week of September so that we can clarify the situation, whether he has done it or not.
Monthly maintenance of rupees 10,000 every alternate month on or before 7th.
Every month, your lordship.
That is
Every month, yes.
every month.
Every
If
month,
it is
yes.
the August amount, then it will come in the 7th of September.
Lordships.
7th of the alternate month. So we'll fix it on 11th of September.
Lordships,
11th of September.
11.
That will clarify everything.
Lordships.
Right? Firstly, heard. Mr. H.P. Das, learned counsel appearing for the petitioner and MS R. Chaudhary, learned counsel appearing for the
Sole
sole
respondent.
respondent. By order dated
11/7.
by judgment dated 29/09/2023 in a proceeding under section 125 CRPC preferred by the sole respondent. FC within bracket criminal case number 280/2016. Learned Principal Judge Family Court number 3, Kamrup, Mr. Guwahati, directed the petitioner to make payment of monthly maintenance of rupees 10,000 per month to his wife / sole respondent in her bank account with the observation that such maintenance will be paid to his wife till clearing the permanent alimony amount of rupees 20 lakhs as fixed in FC in bracket civil case number 264/2015. The further observation that the liability to pay monthly maintenance, say the amount of rupees 10,000, shall be automatically stopped from the date of payment of entire amount of permanent alimony by the petitioner to his wife, the sole respondent. And that until non-payment of said permanent alimony amount, the maintenance of rupees 10,000 shall be paid by the petitioner continuously. But received judgment dated 29/09/2023. The learned family court number 3, Kamrup, Metro, Guwahati, also directed the petitioner to pay cost of rupees 20,000 to the petitioner, to his wife. Sole respondent. Cost of said proceeding his wife, the sole respondent. Due to non-payment of the maintenance line as directed on such and such. His wife, the sole respondent, preferred an execution case being criminal execution within bracket close 3/2024. Wherein the court, wherein the family court by order dated 28/06/2024 found that towards payment of the area, I got the order to Likita 28, from the date of filing of the said maintenance an amount of rupees, area amount of rupees 9,30,000 was found to be due. Wherein the petitioner wait for some time for payment of the area maintenance. By which order distress warrant was issued to you?
The last page, madam, my petition, madam, page 43. Order dated 28/6/2024.
It was not issued as yet. It
Not
was,
issued, madam.
it was the last chance given to him to make the payment.
43 or in the
43, madam, annex 5.
by decide order the 28/06/2024, the London Family Court number 3 in said criminal bracket close execution 3/2024 preferred by the sole respondent. Granted 1 month's time to pay the area amount to his wife. But did not stay the execution and by rejecting the prayer of stay for execution of the said judgment at such and such. Agree. The petitioner preferred this criminal division petition. It is contended by the petitioner that pursuant to the order of the Honorable Division Bench, that is in criminal appeal. Mr. Das?
Yes, madam.
Which case you have deposited?
In the, madam,
Brother,
madam, page 29, madam. Page 29, madam. Matrimonial appeal number 2 of 2024. 29, madam. Page number.
the petitioner preferred a matrimonial appeal. Preferred an appeal being matrimonial appeal 2/2024. With regard to direction of payment of permanent alimony to the permanent alimony rupees 20 lakhs to his wife, sole respondent. Passed by Land and Family Court, Chatham 3, in FC civil case number 2642015. Wherein, pursuant to the order of the division bench of this court in the said matrimonial appeal, Chatham, paid an amount of rupees 7 lakh to the sole respondent. Miss Chaudhary Learned Counsel appearing for the sole respondent. Brought to the notice of the court that though the petitioner earlier filed application interview application for stay of the execution relating to said civil criminal execution case number such and such. The court being IA, put in bracket criminal 272/2024. I ordered the 01/04/2024.
Lordship, that was not for execution petition, that was for the main order of 29.
That is
That is criminal revision filed against the main, the judgment and order of the family court.
29.
29, yes, Lord. 29 to 2023. And in therein he had filed an
That is
IA.
in which criminal?
That's, Lordship, the criminal revision number is there. Criminal revision number is 35, if I'm not mistaken, 35 of 2024.
Annexure 1, page 13. There were two others, my lord. One for the
execution under this court.
one for the multi-maintenance and one for the permanent alimony, my lord. On the same date, order was given.
Petitioner has also preferred criminal revision petition number 35/2024
Wherein he had filed the IA. Deployment.
against the said judgment dated 29/09/2023 passed by the Learned Family Court number 3, Kamrup Metro Guwahati in FC criminal case number 280/2016. Whereby the petitioner was directed to pay rupees 10,000 per month as maintenance to his wife till the payment of the permanent alimony 20 lakhs per. Along with an interrogatory application being IS criminal 272/2024 for stay suspension of the said judgment in order 29/09. Ms. Chaudhary Land Council appearing for this order by placing the order dated 01/04/2024 passed earlier by a coordinate bench of this apprised that the court did not pass any stay order relating to the suspension or execution, but staying the suspension and execution of the said order dated 29/09/2023 passed by Learned Family Court. Considering the submission of the Land Council for the parties and the materials placed before the court, including the affidavits of assets and liabilities of the petitioner, which he had placed before the learned family court. Subject to the payment of rupees 5 lakh. The bank account of the sole respondent, either by way of electronic transfer or by payment of demand draft on or before 30/08/2024 towards the area maintenance out of 9,70
770, 9,70,000,
as of July 2024.
August 2024. As of July, Lordships, one moment. As of July 24, yes,
As of July 2024.
yeah, July.
And subject to the regular payment of the maintenance amount of rupees 10,000 every month.
Till disposal of this particular case. No?
Within the first 7 days of the alternate month commencing from September 2024 in the bank account of the sole respondent. Right. Whereby the vendor for my money transfer. Account transfer लिखे होगा electronic account transfer electronic transfer to date. The further proceeding of money execution case number not money execution proceeding or execution case number pending before the court of
Principal Judge.
Principal Judge Family Court number 6
Principal Judge.
Guwahati.
2, 3.
Shall remain
Three.
three.
Principal Judge 3.
Shall remain suspended. List on 11th of September.
Lordships, may I just say one small, Lordship, it may not be alternate month, it may be subsequent month. because-
Subsequent month.
Subsequent month. I'm deeply obliged. Otherwise, then he'll say alternate.
Subsequent.
He has made me run so.
Okay, you'll get it tomorrow.
Uh,
Let the order be
absolutely.
typed out. And then
So we'll just inform the Honorable Family Court that the
Yes.
subject to this payment
it is already on
this thing. Yes,
online
sure.
camera.
Thing is
So,
there.
they'll be
I'm deeply obliged to your Lordship.
21.
Lordship. 2 week times may be granted for filing objection, Lordship.
Heard Mr.
AMS Majumdar.
A.M.S. Majumdar, Planet Counsel for the petitioner. And Mr. B. Sharma, an additional public prosecutor appearing for this case. Also heard M.S. R. Rangmain, right?
Yes, Lordship. Respondent.
Planet Counsel for the respondent number 2. There is the office notes. seen that the registry has already received the scanned copy of the PRC case number 106/2024. Arising out of client KLA PS case number 310/2022 from the Court of Learned Chief Judicial Magistrate Court of Learned Judicial Magistrate First Class JMFC Kachar Silchar. On the prayer of the Learned Council for the respondent number 2. Week's time is allowed to him to file affidavit in opposition / objection, if any objection in the matter. Released on 30th of August.
My pleasure. So this criminal petition is basically for the modification of the learned courts bill's order, whereby the custody of the vehicle has been allowed, but on furnishing of a bank guarantee. So my humble submission before Lordship that the bank guarantee for the petitioner is impossible because to furnish a bank guarantee, because already the vehicle has been in hypothecated condition, and the petitioner is a third owner, my lord, and he can the it's a depreciating asset, my lord. So banks are also not ready to furnish bank guarantee even to take guarantee. So, my lord, he is ready to furnish any bond, my lord, except the bank guarantee, my lord. As the learned court below has or passed the order while allowing it, cited the section 11(5) of the Cattle Preservation Act, though that bank guarantee, in that case also, in several judgments, in several orders of the coordinate benches of your lordships, has already modified this type of similar orders, my lord. May say, but it's not mandatory.
Yes, what order have been passed?
My lord?
What orders have been passed instead of bank guarantee?
My lord,
Because there is a mandate of the act.
Yes, my lord.
So,
my lord,
11(5) says there needs to be a bank guarantee.
May I refer the coordinate benches judgment orders, my lord?
Do you have a copy?
Yes, I have the copy. There are several orders, my lord. I have relied on only 3, my lord. Yes, what I modify codes.
What is the value of the car now?
My lord,
Vehicle, it's
as per the police, so it's 6 lakhs. But according to the petitioner, it's less than 6 lakhs. It's 1.5 to 2 lakhs rupees, my lord. The petitioner is even ready for furnishing bond of 6 lakhs even. Because, my lord, from the vehicle was seized on 2/7/2023. It's more than 1 year. It's lying in the before the police station.
Yes, Mr. Sharma.
Yes, my lord. Though it is, my lord, 11(5) is clear, my lord, but there are some order of modification is there, my lord, by this honorable court.
Tell us, you're the public prosecutor, you'll tell us, then we'll consider. Your colleagues appear in all these matters.
My lord.
Let it go on bond, that was what I was saying. It's a hypothecated vehicle with all other conditions fulfilled, like taking a photograph.
Yes. Complying the Sundar Bhai Ambala research.
Yes, Sundar Bhai Ambala, yes, he will take it whenever it's necessary. It's a vehicle. No?
Yes,
Thank
it's a
you.
vehicle.
Pick up hand.
Confiscation now.
Did you mention the finance company from which you have taken finance?
My lord, there I have not mentioned, but I have mentioned it that it is hypothecated. My lord will get in my para 9, my lord. But I have the copy, my lord. It's HDB Finance Services.
Heard Mr. M. Alam, counsel appearing.
My lord, BM
A.
Dekar.
Alam, right?
BM Dekar. BM Dekar, my lord.
Counsel for the petitioner. And Mr. B. Sharma, London Additional Public Prosecutor, appearing for the state respondent. Petitioner herein is the owner of Bolero pickup FPMS 1.33 vehicle bearing registration number AS -26 C 7583. Which he had taken on finance. From finance company. Petitioner said vehicle, Bolero pickup, was seized in connection with Abhayapuri Police Station case number 303 of the 2023. Take your seat, Mr. Under section 379 of the IPC. Read section 11, within bracket 1, within bracket small t of the Prevention of Cruelty to Animals Act. Read section 13, within bracket 1 of the Assam Cattle Preservation Act 2021. The petitioner, being not involved in the said Abhayapuri PS case number such and such, sought for Jimma of his said vehicle, Bolero pickup vehicle. আগতে লিখিত case number to corresponding to MGR number 567 for Jimma of his said vehicle seized in said connection with Abhayapuri PS case number such. And the London Judicial Magistrate first class. No, Subdivisional Judicial Magistrate in Bucket, Mafasal Bucket, North Salmara, Abhayapuri. By order dated 19/09/2023. First in said Abhayapuri PS case number 303 of 2023. Do allow
My lord, the order is on 11/8/2023.
11/8.
11/8, my lord.
Where is that you have in it?
My lord will get at page 33.
Eleven 20. First in. The order for release of the said vehicle. It seized vehicle of the petition. But in terms of section 11 within bracket 5 of the Assam Cattle Preservation Act 2021, the learned magistrate by the said order dated 11/8/2023 directed the petitioner to furnish a bank guarantee of rupees 6 lakh before the said court for release of his said Bolero pickup vehicle bearing registration number involved in connection with sale of airport. with the observation that failure on his part to furnish such bank guarantee, the said vehicle, said Bolero pickup car, vehicle of the petitioner, shall remain in police custody of a police station. Later, the petitioner prepared another application before the learned subdivisional SDGM building, 14 Bucket M, North Salmara, Airport, to reduce the value, surety value from rupees 6 lakhs. However, learned SDGM Sasha by order dated 1909-2023 rejected the said prayer of aggrieved the said order of the learned orders were as the JMM. The petitioner preferred a revision petition being criminal revision number 15 in bracket 4 of 2023 before the Court of Learned Additional Session Judge in bracket FTC North Salmara of April. After hearing the Learned Additional Session Judge FTC Normal by judgment dated 1903-2024 first in said criminal division number 15 written bracket 4 of 2023 preferred by the petition. Finding no merit in the said revision petition, rejected the same. Hence, this criminal petition by the petitioner or remove of his said session. It is contended by the petitioner that he is the third owner of the said Bolero pickup vehicle, she is in connection with such. And that as the said vehicle is hypothecated to the finance company where he is yet to liquidate the installments to the concerned finance company. If the said vehicle is not leased, he will not able to pay the installments for the said vehicle. As the said vehicle is the only source of income. It is also submitted by the petition that police, after completion of the investigation inside of Apuri police case number, have already submitted the search sheet on 30/08/2023. And if the said seized vehicle is now kept in police custody of the Apuri police station, it will be damaged, and further its value will get diminished. It is seen that the learned magistrate, while passing the order dated 11/08/2000 SDGM, while passing the order dated 11/08/2023, found the petitioner to be the lawful owner of the said seized vehicle bearing a Bolero pickup vehicle bearing registration number. After considering the entry materials and hearing the parties, the order dated 11/08/2023, passed by Learned Subdivision Judicial Magistrate within bracket, Mafasal, bracket close, North Salmara, in Abhayapuri PS case number 303/2023, modified litigation order is modified to the extent that on furnishing the surety of rupees 4 lakhs with the Learned Subdivisional Judicial Magistrate SDJM, right? The authorities of Abhayapuri police station shall release the said vehicle number such and such after capturing the videograph in the number such as number. The vehicle, copy of the registration certificate of the said vehicle. The petitioner on condition that the petitioner shall not alienate the said vehicle without the leave of the court. I remain resident at the time. And shall produce the said vehicle in proper condition as and when it is required during the trial of the case. And for that. Correct. To the above observation direction, this criminal will stands dismissed.
My lord, one point, my lord. Usually bond is submitted before the police, my lord.
You want to make it before police because already the charge sheet has been filed.
Yes.
That's the reason.
My lord, my lord, my lord.
That's why you're not
My
making
lord.
it before the police.
Much obliged, my lord. Highly obliged, my lord.
May please, your lordship. It's a criminal revision petition, your lordship, against the impugned order passed by the JMXC Naga, your lordship, against the interim maintenance of rupees 10,000, your lordship. To be paid to.
What
the
happened?
Yes, your lordship.
Other side is not here. Normally he is available. Okay, Madam Nazlin will take it some other day. Pardon, Ms. Nazlin, counsel appearing for the petitioner. And Mr. B. Sharma on additional public. To name of the counsel for the sole respondent is reflected in the cause list. The said respondent have been on the list on 19th.
19th of this month, your lordship.
This Monday, coming Monday.
May it please your lordship. Lordship, this is an appeal against judgment dated 22/7/2024,
What's
passed
your
by,
good name?
yes, lordship,
What's your good name?
J. Simpho, lordship. Passed by the learned Special Judge Bijni in NDPS case number 19 of 2022, convicting the appellant under section 20, subsection B, Roman 2.
Part MS is a Singapore learned counsel appearing for appellant and Mr. B. Sharma, an additional public prosecutor. Appearing for the state respondent. Agree with the judgment. Conviction and sentence dated 22/07/2024, passed by the learned special judge NDPS. Disney Chirang in special within bracket and case number 19 within bracket B 2024, whereby the appellant, whereby he has been convicted and sentenced under section 20 within bracket small b within bracket small Roman 2 within bracket small capital B of the NDPS Act with rigorous imprisonment for a period of 3 years and 6 months with fine of rupees 20,000 in default to suffer further rigorous RI for a period of 60 days. The appellant has preferred this appeal. Prefer application on convicted along with another Nityananda Sarkar. Preferred its statutory application. That will be admitted for hearing. B. Sharma listed for respondent number 1, as well as for the respondent number 2, concerned sub inspector of police. By the informant of the case, who in his official capacity filed a search sheet. Copy NDPS case number to the liquid, arising out of the Disney police station case number 161 of 202. Call for the records of the from the Court of London Special Position Bracket indicates. As Mr. B. Sharma narrated that no formal document had to be. The appellant shall furnish 2 extra copies of this memo will be within 2 days from the date of it.
Lordship, you have also filed an IA for suspension of sentence.
This interlocutory application of the applicant slash appellant shall be considered on receipt of the relevant records hearing for a record of the that is called for by order written partially connected list after 4 weeks.
Yeah, please, Your Lordship. Lordship, today we have taken steps, my lord. We could not take steps in the last occasion, my lord.
You have the number?
Yes, my lord.
When you have taken step?
I have in my phone, my lord.
You have
Today-
not taken?
Yes, yes, today morning we have taken steps. my lord.
You have the number with you?
Yes, my lord, we have.
Kindly give it to us. Pursuant to the order of the law, Zimmer Court at 1907-2024. It is submitted by Mr. D. Bora,
D. Bora, my lord.
counsel for the appellant, that he has taken steps on the respondent number 2.
Yes, husband number 2, my lord. We have taken steps several times, my lord, but it has not been raised.
Today. By registered post secretary?
Yes, my lord.
By registered post secretary, as well as by the usual court process to the office of the learned secretary magistrate. That's his name, list of the 6 weeks.
God bless.
Hey, please, Your Lordship. Lordship, I'm appearing on behalf of Mr. I. Kalita, and services awaited, Your Lordship. Notice was sent through speed post to the district magistrate Golaghat. So this may be posted after a week, after 3 weeks, Your Lordship. and there is an interim that may be continued.
Where was the office note?
Lordship.
There is 08/08/2024. It is seen that the notice issued to the respondent number 2, sorry, sole respondent, has been received back by the registry but without the report of the concerned process server. In view of the above, the petitioner is directed to take fresh steps for service of notice on the sole respondent by registered postage on or before 16/08/2024, providing his correct and proper address with requisite postal stamps. The petitioner is also allowed to take steps on the sole respondent by due process to the registry of the score to be served through Suzanne Gulagat. List on 13th of September,
Lordship, interim may be continued, your lordship.
subject to taking steps as directed above. In the interim order passed earlier shall remain in force.
Obliged.
Yes. What is the status of the case?
May please, your lordship. Lordship, I have gone through the last order, lordship, the petitioner is presently posted as the additional deputy commissioner of Darang district, lordship. And the previous case which was, that was subsequently forwarded to Vishwanath Chariali, lordship, and it was renumbered as Vishwanath Chariali PS case number 61 of 2020. After 3 years, bail was granted by this honorable court, lordship. The petitioner appeared before the authorities and given a statement. He has coordinated in every possible way, cooperated with the investigation, lordship. But I think nothing has happened till now, lordship. It is in a state of limbo.
What is has been this all women police case has been stand to Vishwanath
Transferred to Vishwanath Chariali, lordship. And it was renumbered as Vishwanath Chariali PS case number 61 of 2020.
2020.
Yes, lordship, 2020. So
And the petitioner has been posted as what?
He is presently posted as additional deputy commissioner, ADC, Darang district. He was granted 3 years bail versus by order dated
During the deliberation of the Mr. DJ Kapil and counsel appearing for a petitioner submitted that the petitioner has been presently presently serving as additional deputy commissioner district Dorong at Mongoldoy. Mr. Kapil further submit that the all women PS case number 23/2020 involved in this proceeding has been transferred to Vishwanath Chariali and has been re-registered as Vishwanath Chariali Police Station case number 61/2020. List on 28th of August. On the said date, Ms. Anders Planet, additional public prosecutor, appearing for the state respondent. Number 1, shall apprise the court about the present status of the said as trial. All women police station case number 23/2020. Copy of this order.
Yeah.
পুরো 2020 সনের পরে এপিল টু করিয়েছে উকিলের নাম 2020 পরে 2024 স্টেপসে নাইলেও অ্যাপিল করে हमको Appeal number one है ना? कोई legal is and you are aware of Bidyathar Acharya council? The convicted accused filed this criminal appeal. Against this judgment and order dated 02/04/2018 passed by Learned Session Judge Dhemaji in Sessions case number 124 to DH bracket close /2015, whereby he was convicted under section 326/307 IPC and sentenced to undergo rigorous imprisonment for 7 years with fine of rupees 1,000. In default, rigorous imprisonment for 1 month under section 307 IPC and further sentenced to undergo rigorous imprisonment for 5 years with fine of rupees 1,000. In default, rigorous imprisonment for another 1 month under section 326 IPC, where both the sentences to run concurrently. The this convicted from jail really. So this appeal was filed by legated counsel with a delay condonation application. On Mr. B. Athatile, legal counsel filed this appeal on behalf of the convicted accused appellant. Petitioner, the applicant is yet to take step on the response number 2 as per the office note dated 8/8/2024. The matter was taken up for consideration today. The appellant remain unrepresented. Ms. Das, what we have seen
No, sure.
that We'll put the sentence run contract. तो लिखना है order sentence get the information whether this particular convicted accused, considering his period of detention in custody during the trial
No,
or during investigation, has
no,
completed the period or not, because this was an order of 2018, 7 years, April 2018. But the order doesn't reflect whether he was in custody, whether has been produced from the jail custody or he was in bail.
no, sir. I'll take the instruction.
Get the information. This is from Dhemaji.
No, sir.
Because we'll be able to get the information by next week.
Yes, sir.
List on. By 22nd, you'll get it.
22nd, Lordship.
22/08/2024.
22nd, Lordship.
Enabling MS and an additional public prosecutor. To obtain necessary information from the superintendent of district jail Dhemaji about the present status of the accused, convicted accused appellant Ratul Saikia, convicted under section 326 of 307 IPC. Pursuant to the impugned judgment dated 20/02/04/2018, passed by Learned Sessions as Dhemaji in Sessions case number such arising out of practice. Ratul Saikia, son of late Mohan Saikia. A Sessions case petition 124. No. 124 days 2015, arising out of Silavatar Police Station case number 112/2015, corresponding to GR case number 705/2013. Yeah. Copy of this order. List accordingly. None appeared for the applicant on call, applicant on call. No names of two counsels have been reflected in the cause list for the applicant. Matter relates to appeal against acquittal with regard to the judgment and order dated 11/10/2019 passed by Planet Sub-Criminal Judicial Magistrate within brackets order in Sukia. NCR case number 24C/2019 that was filed with a delay of 61 days. Since January 20, since March 2020, this matter is pending for consideration. Delay is yet to be condoned for consideration of the appeal. List after 4 weeks.
Have you the Lordship? Lordship will take steps by tomorrow.
So by order dated 26/07/2022, while issuing notice to the respondent, court directed, while issuing notice in the matter, court directed to take steps on the respondent numbers 2, 3, and 4 by registered postage ID, as well as usual process. The petitioner is yet to take steps on those respondents till date. What's your good name?
R.R. Sekalot. On behalf of JMS Chaudhary.
I'm at such and such. Counsel has entered appearance of behalf of Mr. J.M. Chaudhary, counsel for the petitioner. Also heard And that's got additional public prosecutor appearing to this state respondent. On her preference, the petitioner is allowed to take steps on the respondent number 2, 3, and 4 as directed earlier on 26/7/2022 on or before 16/08. List up to 6 weeks.
Nice.
The prayer of the council for the parties list up to 3 weeks on a date to be fixed by the legislature.
May I plead the lordship? Lordship, inadvertently step was not taken. Lordship, I may grant 1 day time for taking step.
That was in last September.
Yes, lordship.
Are you interested? The petitioner is interested or not?
Yes, lordship. Can you 1 day time? Oh, so lordship. Tomorrow I will take the step, lordship.
Pursuant to the order dated 26/05/2023 and 20/09/2023. The appellant is allowed to take steps on the respondent number 2 informant of the case. By serving a copy of this memo of appeal by public prosecutor to the registry of this. You take steps tomorrow
Yes, lordship.
to the registry of this court on the public prosecutor. The Guwahati High Court. Obtain necessary acknowledgement for a detailed proceeding. On or before 4 की तारीख को दी। और 16 पूरी। ठीक है? List of the 4 weeks. And that to be fixed by the way. ये पुलिस और रिपोर्ट को खुद ही पता। Detail order to sign up. This no.
34. May I please, my lord? Let in this case, my lord, notice already been served, my lord. The chair also received. The notice already been served, my lord. The informant, my lord, in respect of item 32, my lord. I am only regarding the IA, my lord, for my lord bail, my lord. Let petitioner convicted under section, my lord. Convicted under section 341, 323, 373, 34, my lord. I am convicted only due to the common intention, my lord.
Report में है। Is there anyone appeared?
Not,
For the
no, my lord.
installment?
Not appeared.
My lord, I'm appearing for item number 33. We also have one IA. Okay.
Mr. Sharma, any objection filed?
My lord,
Conviction under section 376-34.
yes, my lord, not filed, my lord, yet.
Why? Appeal was admitted long back.
My lord.
You are in custody since when?
My lord, initially during the trial, my lord, initially I was about more than 4 months, my lord. And my lord, presently, my lord, from the date of judgment, my lord, which is from my lord, 18/5/2023, my lord. 16/5/2023, my lord. About 14 months and earlier 4 months, my lord.
And
More than 1.5 years.
during investigation and trial?
During investigation, 4 months, more than 4 months. I was custody from 14/8/2014 to 22/12/2014.
Are you interested to file objection?
My lord.
You are interested, when will you file it?
My lord, next week, my lord. Within this, my lord.
Give us a date. Give us a date.
My lord. 20, my lord. 28.
20.
20, my lord.
Hard. Counsel appearing for the appellant. And Mr. B. Sharma, an additional public prosecutor appearing for the state. Where is the office note? Here. Service of notice is complete on the respondent number 2. That's your right. On repair of Mr. B. Sharma. The London Additional Prosecutor. State is granted time till 21/08/2024 to file its objection. Placed on 27th.
Oblige, my lord.
Yes.
326. About 1 year in custody, objection already filed. In case I file my daughter, I find the real lordship may consider their bail matter because he will be 8.
Okay, we will take it up tomorrow.
Madam?
Tomorrow.
Tomorrow.
He may not be there. We have heard you. Let him be there tomorrow.
Yes.
Will pass. Objection filed already.
Objection filed already filed. In the PW minor 8.
We'll look into it. Tomorrow we'll pass the order.
Time maybe at 2 or your lordship. So your lordship will pass order.
We'll pass the order.
Minor.
Let
Like
him be here. We'll
they are
verify
all
the
along
records.
all along on bail minor.
Look into it.
Obliged to your lordship.
You make a mention in the morning. It will come back. এখন রাখি তো লম্বা নোট করা না কোনো নোট করা
কি কৰিব লিষ্টটো আহিব নেকি এই লিষ্টটো দিব নেকি কি ক'লে
লিষ্টত দিব
হা লিষ্টত দিব নেকি
নেক্সট দিব লাগিব কালি ল'ব লাগিব